Recording in progress.
Give me back the key, please. Hi, everybody. Good morning. Sorry about that. Some practical areas that we address. Look, very quickly, this is following the meeting we had last week, and I think we're starting from the beginning. I think if I'm correct, in Kulileko, we received a further matrix with a slightly updated comments. Apart from that, the documents are much the same. So, firstly, are there any apologies in Kulileko?
Hi, Chair. From the side of members, I don't have any apology. From the stakeholders, I've got an apology from Prof. Quinot, APLU.
Yes, he can't make it, right?
Yes, Chair.
Okay. All right. The other stakeholders are here.
Yes, Chairperson, because they are not using their full names. I presume all of them are here, Chairperson.
Fine. Okay. Shall we go for it then? Can you start the whole process again? Is Mr. Matibula here? And Impi and her colleague?
Yes, they are both here, Chair.
Fine. Okay, both here. Right, let's go for it. Who's leading?
Good morning, Chair.
Fine, yeah.
Good morning, Chair. Yes, I will just briefly introduce, and then we'll allow Advocate Van Score to also take the committee through. Now, thank you very much, Chair. I think we also have a presentation at least today, so that we make the discussions much easier. We'll go through it. There are specific issues that we'll address, of course, in the presentation, Chair. We won't waste time. I just want to also echo what you've just said now, that there is a matrix, and that matrix has got two additional submissions, which were not there before. And that is one of Corruption Watch as well as BUSA, which we put together. And then the rest of the other issues are still the same. The report is the same as we presented last week. So Advocate Van Score will then take us through, Chair, on the content of the presentation. Thank you so much.
Good morning, Chairperson, other members of the committee, and also stakeholders in the meeting. I will firstly deal with the aspect relating to constitutional concerns. The first area deals with preferential procurement. That's dealt with in Chapter 4 of the bill. Now, the concerns raised in submissions broadly deals with the alignment of Chapter 4 with the rest of the bill, whether Chapter 4 is a framework envisaged in 217(3) of the Constitution, and then also clarity on set-asides, pre-qualification, subcontracting, and local production and content, which are the four main clauses in Chapter 4, but there are some other provisions as well. Then firstly, regarding the alignment of the bill with the rest of Chapter 4 with the rest of the bill, it's important that this chapter should be understood in the context of the procurement system that's envisaged in Section 217 of the Constitution. And it is also linked with Chapter 4, which provides for the regulations to prescribe the framework for the procurement system that procuring institutions must implement. And this system also includes their policies. And when they implement the system and policies, it's important that they must take into account the nuances of their particular sector and industry. Now, an important judgment relating to 217 is the Constitutional Court judgment of Agribusiness versus the Minister of Finance, which pertain to the 2017 Preferential Procurement Regulations, where Justice Pankla said the standalone reading of Section 217, which ignores Section 217, is not only a disservice to statutory interpretation, but also ignores the founding values of the Constitution. Now, this, in our view, confirms that national legislation providing for a framework to give effect to 217 of the Constitution must take into account these founding values and also the need to deliberately redress past discriminatory practices and to provide for measures to make meaningful difference to the lives of South Africans who suffered under the pre-April 94 dispensation. And more could be read about this in paragraph 60 of the judgment. Now, further regarding the framework comments, or regarding the framework comments, is section 217, 2 and 3 of the Constitution, in our view, and also confirmed by the Senior Council opinion, means that Parliament is entitled and required to enact legislation laying down a framework for the implementation of a preferential procurement policy that institutions are to in terms of 2172 of the Constitution. Now, the advice that we received is that the question of how tight or loose that framework is, that is how much discretion it affords to organs of state to develop their own policies or depart from national policy, that is for Parliament to determine. Then, as to section 2172, some commentators indicated that this section simply say it does not prevent organs of state from implementing basically a preferential procurement policy. Now, once again, the advice we received is that 2172 in itself does not create an obligation for organs of state to use such policies as envisaged in 2172. It enables it, but it doesn't require it. But the opinion advised that Parliament may, via legislation, require that organs of state use such policies. And this is further augmented in the opinion by reference to section 9(2) of the Constitution dealing with the right to equality, which allow for legislative measures to address discriminatory practices of the past. Then a further aspect regarding Chapter 4 that was raised in a comment is pre-qualification and subcontracting. Now, pre-qualification for preferential procurement and subcontracting as a condition of contract, in our view, are included in a manner that aligned with the aims of section 217 of the Constitution, especially if you consider the majority judgment in the agribusiness case, where the court said in a reference to the 217 regulations, we provided for pre-qualification as well as subcontracting. The judge said happily both the first judgment, that's the Supreme Court of Appeal judgment, and this judgment, and indeed the Minister understands that the impugned regulations do what is envisaged in 217 of the Constitution. Now, another aspect raised in comments related to set-asides. Now, our view, it's not correct to state that set-asides are unconstitutional. Section 217 provides for preference in the allocation of contracts, specifically in 217(2)(a), and then in 272(b) for the protection and advancement of persons or category of persons previously disadvantaged by unfair discrimination. Now, the reason that set-asides were regarded in the agribusiness case as not being legal was that the founding legislation, the PPPA, did not provide for set-asides per se, but for preferential procurement to only occur within a context of a preference point system. So that was the basis of why the court found it invalid. It's because of the text of the PPPA. Further could be read about this in paragraph 69 of the case. Now, Chapter 4 of the bill provides for a menu of preference measures to provide for the meaningful redress of the imbalances of the past. Importantly, in clause 7.6 of that deals with set-asides, recognize that it may not always be possible to implement set-aside provisions, and then it states what should occur in such instances. I think it's the last aspect regarding Chapter 4 that we deal with in relation to comments, and that's local production and content. Now, again, which was referenced earlier, Section 2172 of the Constitution provides for preferences in the allocation of contracts, which preferences may relate to several vulnerable categories, such as the local manufacturing base of South Africa. Now, before sectors or products are designated as provided in Clause 20, the proposed designation is to be gazetted for public comments. And then also in clause 23, it provides that when the threshold is determined, the Minister of Trade and Industry and Competition must, in addition to considering the comments, the public comments, and also the responses of the Minister of Finance, it must consider whether there are sufficient local manufacturers in the country capable to compete for the provision of goods to be designated. And it must also consider the economic impact on imported goods. And when determining whether there are sufficient local manufacturers, the bill sets out criteria, which is there indicated in paragraphs Roman 1 to 4. Now, in our view, we believe that the necessary checks and balances have been contained in clause 20 to provide for a designation of sectors for local production and content. There's a last aspect in relation to chapter 4 is clause 21, which was not necessarily raised in comments that were submitted to the committee, but we do have a concern about the scope of this provision, which provides that if the preference or that's provided for in 17, which is set aside, 18 pre-qualification, 19 subcontracting, and 20 local production content, if those measures are not applicable, then the Minister may by regulation prescribe how preferences must be allocated. So we propose that the bill be amended so that this power be circumscribed in more detail to ensure that it's not too wide. And we at this stage still considering what kind of amendments we should propose to the committee. Then the next area regarding constitutional concerns relate to the 5 principles in 217 of the Constitution. The view by some commentators were that the 5 principles in 217 are being overridden in chapter 4. Now, firstly, we would like to make the point that there's various provisions in the bill that deals with these principles, and it will be augmented by regulations. And to encapsulating all these principles in the bill through balancing them or choosing one over the other, in our view, are not feasible and not appropriate. Now, the 5 principles in 2171 must be adhered to together with what's provided for in 2172 and 3, as well as section 1051B, which deals with the effective use of resources by government, and then also 216 that deals with national legislation setting, amongst others, treasury norms and standards regarding transparency and expenditure control. Now, when the bill is enacted and the relevant regulations are made, these will direct procuring institutions in implementing these 5 principles in their systems, and those systems, as indicated earlier, would also include their particular policies for procurement. Now, the view that the provincial procurement in chapter 4 overrides the principles in 272 argues from the premise that there's a conflict between 2171 on the one hand and 2172 and 3 on the other hand. Now, in our view, all the provisions of 217 are anticipated to coexist within the procurement system, and that's envisaged in 2172(1). Now, another matter relating constitutional concerns is the scope of the bill. A view or views that were held is that it goes beyond the provincial procurement framework that's required to be set in terms of 217(3) of the Constitution. Now, the first point we would like to make is that national legislation like the PFMA and the MFMA are within Parliament's legislative authority, and in this regard, 2161 are quite critical, which requires national legislation to prescribe measures to ensure transparency and expenditure control in each sphere of government, meaning national, local, national, provincial, and local, by introducing, among others, uniform norms and standards. It's submitted that uniform norms and standards includes the regulation of procurement for national, provincial, and local government. Then on the issue of corporate governance, there was a view expressed by a few commentators that the bill infringes on the constitutional status and powers of provincial and local government. And once again, referring to 216(1) and 2 of the Constitution, which is indicated here there. When it comes to Chapter 4, as indicated earlier, it's based on Section 2173 of the Constitution, and it's a requirement of Parliament to make such legislation and to prescribe a framework for the policy in 2172 of the Constitution. Now, and I think there could be no doubt that 2172 applies to organs of state in national, provincial, and local government. Now, further, the regulation of provincial and local government in the bill is comparable to the PFMA, the MFMA, and the Triple PFA. Now, the MFMA contains a chapter on supply chain management and a separate set of supply chain management regulations that were made by the Minister of Finance. And then in terms of the PFMA, the Minister may make also regulations regarding procurement, which is applicable to national institutions as well as, that was admitted, also provincial institutions. And these regulations are contained in the 2005 Treasury Regulations as amended. And as the Triple PFA currently, apart from applying to national departments or institutions, it also applies to provincial and municipal institutions. Now, what the bill proposes is that procurement, including preferential procurement, be regulated in a single statute, and that, in our view, is not precluded by the Constitution. As the legislative and executive authority of municipality in terms of Section 151 and Section 156 of the Constitution, Clause 6 of the bill makes it clear that the procuring institution, for example, a municipality, must implement a procurement system which includes a procurement system, which must comply then with the procurement system that's prescribed by the Minister of Finance under Clause 25 of the bill. Therefore, a municipality's authority in this regard is not impacted. As to consulting the Minister of COPTA, which is mentioned in a number of submissions, there's already a requirement in Clause 64(2) that whenever particular legislation affects the portfolio of a minister, then there must be such consultation. Now, in relation to cooperative governance, from the comments that received, there was certain points raised that we would support or propose amendments for consideration by the committee. The first one is that the authority of the Public Procurement Office and provincial treasuries to issue instructions that are applicable to municipal institutions be replaced by what we propose to be called a circular, which a municipality then has a choice to adopt or not. And this is similar to the practice followed under the MFMA and I think also the Municipal Systems Act. And then further, it's proposed that the enforcement function for provincial treasuries regarding municipalities and municipal entities be omitted, because I think the point raised in the comments are valid, and the enforcement function that you will see in 2162 of the Constitution is limited to National Treasury. Then a further comment raised was that we should specifically provide for consultation with organised local government, which is currently represented or a recognised institution is SALGA. So we propose that such a clause be inserted in the regulation provision. Now, stepping off from the procurement of the constitutional issues, the next area that's raised in comments is the independence of the Public Procurement Office. Now, views have been held that the Public Procurement Office must be independent and not be part of National Treasury. Again, referring to 2162 of the Constitution, which stipulates National Treasury must enforce compliance with uniform norms and standards relating to what's in 2161. In our view, as stated earlier, includes procurement. Therefore, having the Procurement Office in National Treasury, in our view, accords with 2162 of the Constitution. I think an important point also to note is that the bill proposes to confer regional powers on the Public Procurement Office, which will provide for separation from the other functions of National Treasury. So the PBO wouldn't be dependent on delegations from either the Minister or the DG of National Treasury. Now, the Procurement Office functions pertain to when government procures and not when the private sector procures. Therefore, in our view, there's no need for the Public Procurement Office to be independent since it performs a function for government, and similarly also in the case of provincial treasuries. Now, the next area is the functions of the Procurement Office and provincial treasuries. There was questions asked about the respective roles of the Procurement Office, provincial treasuries, and then also procurement institutions. In our view, the functions of these three categories are clearly set out in the bill if you look at clauses 5 to 8. Now, the functions of provincial treasuries are similar as the Public Procurement Office, but obviously they'll operate within a province. And then there are some functions of the Procurement Office, the national one, as part of its role to set uniform norm standards through instructions, which is only applicable to, would be applied nationally, also to provinces and, not the instructions as proposed to municipalities. Then to note also that the functions of the Public Procurement Office are comparable to the current National Treasury functions under the PFMA and the MFMA. As to the issuing of binding instructions, it's important to note that it's only where so specified, where the specific clauses where it's stated that the PPO must issue instruction, or more generally where it's required for the effective implementation of the Act. For provincial treasuries, there's a similar power to, in respect of the province in relation to the effective implementation of the Act in the province. As indicated earlier, we propose that these instructions should not apply to municipalities, but there should be circulars issued that they would have the choice to adopt or not. The next area is decision-making on procurement. And there's a view expressed that there's a centralization of procurement. Now, we submit that the bill does not change the current position on decision-making on procurement. The bill does not propose that the Public Procurement Office will be the chief buyer for government. Clause 7 stipulates that decision-making on procurement rests in the accounting officer, which would be the term used for departments, constitutional institutions, municipalities, and municipal entities, and accounting officers, so they will also have that authority to make decisions on procurement. And accounting authorities is the term used for public entities listed in the PFMA. Now, accounting officers and authorities must implement the procurement system, including a policy in accordance with the bill, once enacted, of course, and the framework determined by regulation. And these are dealt with in clauses 8 and 25 of the bill. Now, the alignment between the PFMA and the MFMA and the bill are provided for via recognizing that accounting officers or authorities or their role in making procurement decisions, and also specific proposed amendments to the PFMA and the MFMA that's included in the schedule to the bill. The next area relates to integrity, transparency, accountability, and anti-corruption measures. Now, views expressed by a few commentators that the bill is not doing enough, anything or enough for integrity, transparency, accountability, and anti-corruption. Now, firstly, I think it's important to note that the bill is premised in 195, 216, and 217 of the Constitution. All these provisions embed or refers to the requirement of transparency. Now, the fight against corruption and anti-corruption measures need a collaborative effort with other government institutions and also law enforcement agencies. And in our view, it should not be the only instrument to combat corruption. Now, as to the anti-corruption agency, as proposed by the Zondo Commission, in our view, is best placed with departments in the justice cluster, because it's not limited to procurement matters. Then further as to this view that not enough is done or not anything is done, note should be taken that the bill provides for codes of conduct for everyone involved in procurement. Suppliers, bidders, and officials, and members of the tribunal, and so on. And it also provides a provision of undue influence in the procurement process, and also penalize that or make it a criminal offence if that occurs. It provides for the declaration of interest by role players, then also for the automatic exclusion of specified persons from submitting bids. Then there's a further provision about the debarment of bidders and suppliers that have transgressed the requirements of the Act or the regulations. Then there's also protection of officials that receive directions that are not consistent with the provision of the Act. Then lastly, there's apart from the one mentioned earlier, there's a list of criminal offences that relates to giving false information, also conniving or colluding to commit corrupt or fraudulent acts. And then lastly, more about transparency matters in the bill. Apart from it being mentioned under the objects clause, transparency is also provided through the department register. There's provisions for access to procurement services and also open data. And there's also access for provided for the procurement processes in clause 32. Then clause 33 deals with the disclosure information. And then also I think important for transparency purposes, the making of regulation instructions, which has to follow a public comment process. And obviously all these transparency measures should assist in fighting anti-corruption and also ensure better accountability. Then the next area dealing with whistleblowing, incentivizing whistleblowing and protection of whistleblowers. Now there's a view that the bill should do this. Now we do support the strengthening of the protection of whistleblowers through amendments to the Protected Disclosures Act, which is administered by the Department of Justice, and that it shouldn't be done through this bill. The Minister of Justice published a detailed discussion paper in 2023 for public comment, and the public comment period closed, and we were informed that they're working on the amendments, and they also requested that we submit all comments relating to whistleblowing to them for consideration, or that received during the process of Parliament on this bill. Now, during the public hearings in provinces, stakeholders raised, among others, the following concerns on introducing incentivized whistleblowing. As this would create, they think this would create an unwelcome market of criminal conduct. Unscrupulous people would plant information implicating persons involved in procurement, fabricate proof, and then later attempt to claim payment, and so the cycle continues. Now, it was quite firmly stated that instead of paying whistleblowers, they called for enhanced protection of whistleblowers. And they referred to a recent incident where the official was tragically killed, and asked how much money can save a life. Another area raised in comments is how will the Act, once enacted, relate to other acts? Now, the bill refers to several other acts that are relevant or appropriate for the implementation thereof. The Protection of Personal Information, Promotion of Administrative Justice Act, the Construction, can I use the full name Act, the Companies Act, and also the BBBE Act. Now, provisions of some of the acts are proposed to be amended in the schedule for the bill, and we want to indicate we would like to scrutinize this further in view of stakeholders' comment that they received, that we make sure that all the requirement amendments are made. Because although there's a trumping clause in clause 3 of 4 of the bill, we submit there should be limited reliance on such a trumping clause to decide what legislation should apply in a particular case. Then a further area of comment related to the tribunal, the remedies for consideration, and the reviews by the tribunal. Now, the dispute resolution procedures are aimed at saving costs, not only for government, but also for suppliers, for bidders and suppliers. And it aims to improve turnaround times in service delivery. Now, the remedies for reconsideration by procuring institutions and reviews by the tribunal, in our view, are clearly set out in the bill. Now, just for example, sake, there are tribunals that are provided for in existing legislation in South Africa. For instance, the Financial Services Tribunal that's established by the Financial Sector Regulation Act of 2017. And then there's also a provision, a tribunal provided for under the Social Assistance Act of 2004. Now, this is a remedy, the tribunal, to be used before seeking judicial review by the courts, and this is clearly indicated in clause 54.1. One of the concerns raised about whether there would be the ability to deal with so many applications across the country. Now, the bill currently provides that the chairperson of the tribunal must constitute a panel for each application. Now, it is proposed, also in view of comments received, that clause 48 be amended to specifically deal with regulation of panels and the requirements of their operation at the provincial level, so that they can sit in provinces to deal with applications for provincial institutions and municipal institutions. Now, the issue of costs were raised also in a number of comments, but we do admit that that must still be fully costed, and once that is done, provision will be made through appropriations from the National Revenue Fund by an Act of Parliament. And that could also only be proposed, following the normal budget process, consider cost, and when the tribunal is ready to commence its work. Then another area is the question of the balance between the Act and regulations. Views are held by several commentators that there are too many areas that are to be prescribed by regulations. Now, it's important to keep in mind that national legislation envisaged in 2161 and 2173 of the Constitution includes subordinate legislation according to the definition in section 213 of the Constitution. Now, the bill aims to set a framework for procurement with specificity to be provided in ministerial regulations, PBO instructions, as well as some from provincial treasuries. And then the procurement systems and policies of institutions must be determined in the framework of the bill, the Act, and the requirements of the regulations, and where applicable, the instructions. Now, the primary reason for this is to allow for different regulations to be made for different categories of procurement, for example, infrastructure, capital assets, normal goods and services, and also providing consultants specifically, and also different categories of institutions. For instance, maybe different regulations for municipalities in certain areas and for national and provincial. And also, importantly, to cater for new developments in procurement. Obviously, it's easier to amend regulations because then you don't require to go through a parliamentary process to amend the primary legislation. But notwithstanding the above, I think it's important to note that the process to develop regulations is rigorous. The regulations, the draft regulations must be published with a statement of need, intended operation, the expected impact, and then also the relevant ministers must be consulted, and it must be subjected to parliamentary scrutiny, and as proposed earlier, that organised local government must also be consulted in relation to regulations affecting local government. And then another area about financial implications. Now, concerns were raised about the financial implications of the bill. Now, the elements of a procurement system that's set out in clause 25 are existing elements in institutions or functions, which may only have to be made part of the procurement system of institutions, if not currently the case. Now, as to expanding the scope of the procurement function in institutions, most of them are not new functions of institutions, but are elevated to primary legislation instead of currently dealt with in regulations or instructions. So the shifting of those functions within the institution should result in minimal cost. Now, the enforcement function for provincial treasuries is not new. It's already provided for in respect of provincial departments in Section 8.2b of the PFMA. And as proposed, I think it would be a new enforcement role for provincial treasuries in respect of municipalities. It's now proposed to be removed from the bill. Now, as the investigations about allegations on corruption or transgressions which are provided from clause 27 and the steps that should follow are functions that are currently required in terms of the PFMA, MFMA and the respective prescripts and are not new. Then another area in the investigative powers of the Public Procurement Office. Now, clause 56 makes it clear that the purpose of these powers is for compliance purposes and it's not to investigate alleged criminal conduct. Just to mention a few examples, there are currently several regulatory or supervisory bodies that have such powers. For example, if you look at the Financial Sector Regulation Act, the Prudential Authority and the Financial Sector Conduct Authority have such powers, and also the bodies dealt with in the Financial Intelligence Center Act, and you will also find certain Caesar powers in the Property Protectionist Act. Now, these are all acts that were recently passed or amended by Parliament. Then another concern was raised because somehow it was seen, the thinking was that the seeking of warrants may also be done by other institutions, procuring institutions, but it would only be a person that's authorized by the Public Procurement Office that may seek a warrant, which would be required in some cases for search and seizure. Then lastly, just to highlight that apart from the amendments that's proposed in Treasury's report, summarizing the comments or indicated key points from the public submissions, which also, I think most of them are included in this presentation. The comment matrix contains other proposed amendments that we really actually started putting it together for consideration by the committee. Thank you very much, Chairperson.
Willie, do you want to add anything?
Yeah, thank you, Chair. I just wanted to say around the issue of Chapter 4 and re-emphasize the fact that Chapter 4 is a function of the Constitution as indicated. I think that's very important to stress that particular issue. And of course, all the provisions of Chapter 4 are quite important. And I think they've also been carefully researched. The other part is around the fact that it's important that the issues around industrialization are critical issues. We spoke about them previously, including beneficiation in the country to make sure that at least we don't export jobs to other countries, but at least we use our own raw materials to make sure that we promote our own industrialization in the country. That's very important. And I think that's the power that we said we conferring to the minister responsible for trade and industry. Then the other issue, Chair, the tribunal, also very important. I mean, if one looks at the number of litigation against the state, I was joking the other day and say I went to the state attorney and I saw a pile of files, litigation against the state, pile and pile. So, and there's a lot of it in procurement. And this litigation stifles the service delivery in a way. So what we're saying, at least we are providing a mechanism to expedite dispute resolution in the form of tribunal, and also to reduce costs, not only cost to us as a state, but also cost to the people that may not have, especially small businesses, who do not necessarily have deep pockets to take the state to court. And of course, that's the turnaround time in terms of what needs. So it's important that we look at that issue. Then the other issue, Chair, you know, from stakeholders around the fact that, you know, the regulations seem to be giving too much powers to the minister instead of providing for some of these things in the primary legislation. And I think I must also emphasize, Chair, that in terms of that section 239 of the Constitution, regulations, of course, are also part of what is supposed to be called legislation. And the reason why we don't have in chapter 5 in particular, because that's a very critical chapter. It's a chapter, you know, which will ensure that a practitioner, a Willima Tebula or any other person out there is able to follow a particular process in terms of the procurement processes. So what we're saying here, because in the country, we've got, for instance, if you take infrastructure, we've got different types of infrastructure. There's road, there is rail, there is energy, there is water, bulk water, etc., etc. And it makes sense to then detail all these things in the regulations rather than putting them in the primary legislation. That for one reason, and also the fact that you've got different procuring institutions with, you know, different mandates. So it's important that at least we look at specific regulations that will fit a specific procuring institution, including a sector. So this is a departure from a one-size-fits-all kind of approach. That's what we want to make here. So there's a lot of work that still needs to go into the regulations, Chair, but at least briefly we do have at least an overview of what form should the regulations take. So it's very important that we also raise that particular issue. And insofar as the other issue that has been raised around anti-corruption measures, the whistleblowing in particular, as indicated previously, we do not object to that. In fact, we support the enhancement of measures to deal with whistleblowing. But as indicated, we believe that the Protected Disclosures Act is the relevant piece of legislation that should accommodate the protection of whistleblowers. And the incentive as proposed, and I know that when we were at NETLEC, there was a view that at least there should be 100,000 paid per case. And then when we posed the question, where will this money come from? And people are saying, no, this would be coming from a successful prosecution, and then you pay 100,000. But we still don't think it should be incentivized. But the measures to deal with the protection of whistleblowers is very important. So it's a critical issue that we need to look at. And then we would urge also and even from ourselves as Treasury, I think we will also provide our own input into the paper that has been published by the Minister of Justice to deal with the issue, so that we're also in sync. We did have justice during the NETLEC process coming, to deal with this issue specifically. But I think it's important that as they go through and amend that particular legislation, we also take part as part of that process, Chair. So these are some of the issues that I think are quite important that we need to at least add to what the advocate has just proposed now going forward, Chair. Thank you very much. Back to you, Chair.
Thank you, Willie. Okay, hands up, please. No, hang on. We need the participants responding. So you can just put your hands up as you want to speak instead of me going. If you want, all right, I'll go through the order if you want. The Chartered Accountants, are you here? No. Okay. Public Affairs Research Institution, PARI? No. Busa, are you here?
Sorry. Yes, we are here.
Who's we now?
I'm sorry, sir. It was the Public Affairs Research Institute.
Yeah. Okay, fine. Go ahead. Do you want to respond?
Sure.
We can give you up to 5 minutes. I'll monitor it, right? Please don't condemn me. It's scientific thing of 60 seconds in a minute, right? So you got 5 minutes. Here we go.
Sure.
Go
Okay.
right ahead, please.
Mr. Karim, just to mention, I'm actually doing 2 responses. One will be later for the joint strategic resource. But this one is.
All right, why don't we take both together?
Sure. Happy to, if you'd like to do it that way. Yes.
Yeah, let's do it together, yeah.
Okay.
Okay.
So
But you
we'll
don't
do
have to use your full
10
10
times 60
minutes. I mean, you know, yeah. Okay. You can come
Yeah,
back when there's
fine.
space later. Good. Go ahead, please.
Okay. All right. So first, I should just actually reiterate that these are 2 separate institutions. So Professor Claren, I'm from WITS. The participation in the joint strategic resources, this committee will know, effectively is a carry-on from the participation in NEDLAC. Mr. Matabula was just referring to that process. Public Affairs Research Institute is a kind of think and do tank, which has been around for quite a while. It's affiliated with WITS and with UJ, but it's an independent entity. It was able to participate. It's been researching and working in the area of state contracting, public procurement for about 10 years, and closely at times working with the OCPO and National Treasury. So I'll do 4 points. One will be kind of particularly Perry, and then the other 3 will be JSR. And I think one can say subscribed to by Perry. I apologize for the Perry colleagues, Ryan Burnett and Sarah Meny-Gibert. Sarah Meny-Gibert is actually at the parallel MAPS process, where I think as many of you will be aware, the World Bank is consulting or working with Treasury on their usual MAPS process around the public procurement system at the moment. I think that report is probably going to come out soon. Okay, so the 4 points are, 1, just on a process clarification. I think and the National Treasury has responded in part to the comments that were made by individual stakeholders at the provincial legislatures. So really just to clarify that that is indeed what is happening here. I think the comments by National Treasury, as I understand them, are not to the comments of, for instance, the committee or the province itself. So I was actually also one of the stakeholders in the Gauteng provincial legislature. And as far as I'm aware, they are still deliberating, the provincial legislature is, and still formulating whatever might be their own comments on the bill. And I'm sure we'll hear more from the chairperson in the committee about the way forward on that. So that's the first point. Second, substantively, I think there's really something very much to be welcomed in the National Treasury response. There's a sentence in there which is stayed in there saying the spirit in which the constitutional issues are discussed by the stakeholders is appreciated. So I think it's really fair, certainly, from both Perry and from the JSR to return the compliment here. I think there's the spirit in which the constitutional issues have been discussed in the National Treasury response is now mutually appreciated. So just to fill that out a little bit, and Chair, I'd just like to know how many more minutes I've got.
Yeah, look, we're not going to be like draconian about it, but you're at 4:03. We'll see how it goes. Please go ahead.
Thank you, sir. Okay.
You can't speak forever. Yeah, it's better you take your 10 minutes and I come back to you, to be fair to others. I think some of them are not here anyway, so you will get more time later, yeah.
Okay, fine. Just to, I think there's 4 kind of sub-bits on this mutual appreciation around the constitutional issues. One is we've got the very welcome disclosure of the Senior Counsel's opinion from April 2023. I think it's fair to say it's a little, one might have wished that it could have been disclosed even earlier, but I think it's a very helpful and clarifying opinion. There may well be nuances, there may well be even disagreements, I'm not sure, but it's definitely a helpful way forward. In fact, I think it could actually enrich this discussion and be pulled through more. We have, secondly, for instance, a novel, I think, constitutional argument from 216 sub 2 regarding the independence, or at least maybe I should be careful there to say the placement of the authority currently styled as the Public Procurement Office in National Treasury, that's actually arguably required by Section 2162. I should note that the senior counsel's opinion was on 217, not on 216. And it is important as the constitutional issues go forward to distinguish carefully between 216 and 217, at least in our view. Third, in the National Treasury response, there's a welcome engagement with the question of not only the independence of the Public Procurement Office, but also its separation, its internal structuring within the National Treasury. That's on pages 8 to 9. And here we've got the understanding the distinction between the chief buyer and the chief regulator, and then also the important nuance agreed that the regulation here is not exclusively of private firms, so it differs in some sense from regulation of other, quote, industries. And that's an important nuance. I think this set of issues would be important to cascade down at the provincial treasury level. And then the last point on this mutual appreciation is just to point out that we're really beginning to discuss much more, for instance, the Agribusiness case, both in its Concord manifestation and the Supreme Court of Appeal. So I don't want to make everything into a legal issue, but there's appreciation of the driving force of constitutional issues here. I think I'll skip the last point that I'd like to make is really around the whistleblowing. So that'll be, I think that's definitely a position that's effectively adopted by the JSR, but that's been long developed within PERI. So there are many different types of whistleblowing, and both Mr. Matabula and Advocate Van Schuur addressed incentivized whistleblowing in their brief comments now. PERI's long maintained that one type, this incentivized whistleblowing, for persons providing information which materially aids in the recovery of funds for procurement, corruption, and contract fraud, be in this bill, or at least recognized in this bill as a power. This accords with the repeated point made by Chief Justice Zondo and the SIU that the majority, by far the majority of state capture occurred in the terrain of public procurement. So I think the point to make is that is to really ask National Treasury if indeed there is a view on incentivized whistleblowing from National Treasury. In this presentation here, it appeared from Mr. Matabula that the view was that this should not be engaged in. I think if I understood Advocate Van Schuur's position correctly, or her comments correctly, she was saying that there were some comments from individual stakeholders, for instance, in front of the provincial legislatures, that were saying there were issues that would need to be dealt with, such as persons being implicated and wishing to gain money purely, sort of excessive money in that sense, that would need to be dealt with. And we agree with those comments that those issues would need to be dealt with.
You've got 50 seconds left, my friend.
My chair, I think I'm done.
Thank you very much. We can come back to you. I mean, just to be fair to everybody, Busa is not here, I take it, from what I can gather. African Procurement Law Unit, where are you?
They are not here, Chair. They sent an apology.
Joint Strategic Resources covered, I think. National Research Foundation? Not here. Okay, Kosatu and Satu.
Chair, we are very much here. Thanks very much.
Yes.
Greetings, Honourable Chair. Greetings, members, and the colleagues who've joined from various public interest organizations, etc. Chair, let me start with a couple of comments, and then I think my sidekick, Comrade Matthew, may come in for a little bit. We'll try and stick to the time period. So Chair, useful to hear the comments from Treasury. I'd like to echo some of the sentiment that, you know, we are appreciating some of the collegiality with the engagements with Treasury, even if we remain frustrated at some of the stumbling blocks between us. You know, colleagues will know in all kinds of relationships there are challenges communicating, and it does feel like there are some real basic things that we are not managing to hear each other on. So Chair, I want to just kind of focus on a couple of those things here. At the highest level, I suppose, you know, there is some alignment between many of the colleagues, both commenting on this as well as in the NCOP, as well as from Treasury, on many of the high-level principles here, Chair. It's not surprising we all want a more efficient, effective state that rolls out its service delivery progressively. And a large number of us here also see the need for a transformational component to the work of the state through public procurement. Not everyone agrees on that. We know there are colleagues who are vehemently opposed to that, but we certainly think that there's largely alignment there. So our concerns, Chair, are not at that level of principle. It's really about whether or not this bill does the work to enable those things. And I think we've pointed out previously, Chair, that we think that's not really happening. There are some significant problems that remain embedded in the bill, and are also not sufficiently addressed by the comments from Treasury. So kind of the high-level takeaway, Chair, is that we remain of the view that there needs to be a return to NEDLAC for a period of time to work through some of the contentious issues. Let me flag some of these. Treasury's come back on some comments around constitutionality. We won't speak on all of those matters here. But what we do think, Chair, it's clear that whatever comes out of Parliament on this bill is going to be challenged in court. So that's a no-brainer. Whether it's the most remarkable nirvana or whether it's the most destructive, terrible bill, it's going to be challenged in court. Some interest group somewhere is going to challenge it. I guess our need is to make sure that we have the best opportunity to win a court challenge as possible. And that's why we flag the issues of constitutionality. We're not clear that at the moment, if this goes through, that in fact, we're not going to just get a hiding, but we're going to undermine fundamental parts of the bill and be sent back repacking at some stage. So that's kind of a headline principle, and it's not a small thing. And we're going to start on the issue of price. Now, Chair, it's a little embarrassing as a trade unionist to come here and say, you know, as Kosatu and Saktu, we love price. We don't love our state to spend more than it must, because that's not really what we believe. We believe that there should be a premium spent by the state on transformational aspects of public procurement. So we don't have a problem with the principle of premiums in public procurement. But that doesn't mean that we think there should be an absence of price in public procurement legislation. It sounds so dire as to be, you know, almost existential as a threat. And why is that? It's because it leaves a constitutional component and a constitutional imperative unaddressed. The issue of cost effectiveness, the issue of transparency. Treasury's response in its document suggests that, Chair, they want flexibility. But if they wanted flexibility, we would just have nothing in the bill then, because we would address nothing in the bill and put everything in regs. So why is it that price is not in the bill? It doesn't make sense. If we want flexibility, let's have an absent bill with nothing in it and leave everything to regs. But obviously that's a ridiculous outcome. The same for price. Why would we leave price out? The danger of price, Chair, is if you say nothing about price, you hand a silver platter to every member of society who is freaked out that the state is abusing public money. And the reality is there will be abuse of public money. So why don't we put a guardrail there? It's really not clear to us. The same is true, Chair, for other issues that are being kicked into the regulations. Now, look, we understand the need that a bill can't deal with everything. We understand the need for flexibility on regulations.
So
that's cool.
4 minutes.
That's you got 4 minutes left, are you saying, Chair?
No, obviously not. You've been given 5 minutes, so you have
Okay.
4 minutes. Okay.
Okay. So we understand that there needs to be some level of flexibility, but we don't think it's smart to kick everything to regs, Chair. At this point at the moment, we're kicking so many of the clarities and guidelines and principles around selecting around preferences in Chapter 4 to regs that we think there's going to be a problem. And we sketched some of those. We think that there needs to be a rethink of some of the principles, some of the guardrails, some of the guidelines that will work there. In my last couple of seconds, I'm going to touch on 5 issues quickly. There are missing things in Chapter 4, for example, unequal treatment of different kinds of preference. For example, the requirement for market research on designation, but not on other forms of preference. It doesn't make sense that we apply different kinds of considerations and requirements to different kinds of preferences. We highlighted in our previous concern the issue of carving up of tenders, the fact that we're going to make the tender environment or basically unable to sustain legitimate businesses. That's not addressed by Treasury's comments, which say you'll deal with that in regs. You can't deal with that. That's a principal issue of selection. There's issues we've raised around confidentiality, that the confidentiality issues in Clause 1 require POPIA. Chair, the civil society has huge experience trying to extract information from the state and consistently learns that PIA is better than POPI for these issues. So there's a theoretical justification from Treasury given to hedge confidentiality on POPI, and we can say from experience that's not the way it works. PIA would be a better instrument. We want to engage on it. The last 2 ones, and I'll do this in 20 seconds.
Please, very quickly. You can send it to us in writing. It's not fair on others, yeah.
Okay, so then there's an issue on automatically excluded persons, Clause 11. Basically, Treasury is suggesting that information resides in the CIPC. We think that's misleading. We'll provide comment on it, but what we're looking for is a national register of excluded persons for public oversight and transparency. And the last one, Chair, was that somehow through both NEDLAC and Cabinet, it was acceptable that leaders of political parties would be excluded from tenders, and somehow Treasury now says it's unconstitutional. It can't be unconstitutional. It's just inconvenient, and we want to bring that back into the final bill. Thanks, Chair.
Okay, next, please. The Business Research Foundation is here. It was National Research Foundation here, sorry. Can you come on now? Lindy, where's...
Yes, Mr. Karim, it's Ron Grace.
Yes, please go ahead. Sure. Go ahead, please.
Good. Thank you, Chair. And just to express appreciation for your approach. We really appreciated you putting National Treasury under pressure to go to the next level, to up their game, and to respond to everything. And we would love to say that we've met with National Treasury. We'd love to say that they have responded to everything, but that's not the case. So just very quickly, we've downloaded a document in the chat in which we've highlighted that which has not been addressed. Just to give a sense of perspective, in the first round of consultations with the NA, we had about 300 of the 2,300 comments. National Treasury, as we indicated at our last consultation at the NCOP level, had dealt with a small fraction. The latest response of National Treasury, again, only dealt with a very small percentage, and in their response, the vast majority of the responses were actually non-responsive. So comments like noted, or comments like just quoting from the Public Procurement Bill is not really an answer. They haven't really, I think, Chair, respected your wish that we strive to achieve sufficient consensus, and that's been lacking. So the impact of that, from what I understand, is that the legal obligation at the moment sits with Parliament, and particularly with your committee. And National Treasury, we've been advised, are really exposing Parliament and this committee by not adhering to the requirements of the committee. Chair, you've said you don't expect to read everything. But you do expect National Treasury to engage in everything, and failing which it then exposes the committee and Parliament. Now, so if I can just summarize at a high level, because of limited time, a good procurement system should be economical, efficient, effective, in a South African context, should limit corruption, and really promote transformation. Our view resonates with that of the community of practice in the country, that the procurement bill in its current form, taking into account all the proposed changes, will achieve the opposite goals. And I'm using both the historical argument of National Treasury's historical performance and the proposed trajectory in terms of the procurement bill. Based on what we are seeing, procurement will continue to be a lot slower, a lot less efficient. It will be a lot more expensive. The quality may be compromised because of giving an inadequate toolkit. You can't give a brain surgeon an axe to commit to do brain surgery. So you need to give the appropriate toolkit. There has to be diversity of instruments that are allowed, and that's particularly prevalent in our space. So, Chair, we've in the past summarized at a high level the key concerns, and those are available at the National Assembly stage, the recordings. Because of time limitations, I'm just going to limit myself to a number of the key points. Number one is inadequate oversight of National Treasury. If we accept the de facto situation that National Treasury will not have an independent...
4 minutes, 20 seconds. I think we can give you up to 6 minutes. But remember, you've gone to National Assembly. You've had a public hearing with us. You were given a full 10 or 15 minutes. I think it was 10. And what we have here is now taking things further. You can engage with us in a pithy, direct, precise form, having heard Treasury today in 2 pages of. But if you give us 140 pages, you think the British Parliament or the US Parliament is able to do that? We said we can't read everything, but our researchers will. They'll split it amongst themselves on a content advisor, and we will do what we can. But I think people are seeking to now have another public hearing where they're repeating things they've said before. And I would urge that you focus on precise things in a nutshell and send us a 2-page or a 3-page of what more you want to raise with us beyond what you said. But I'll give you an extra 2 minutes. Please go ahead.
Thank you, Chair. So we've made significant contributions.
I don't know. The members want to comment. Can I make something clear? The way it works is you're given between 2 and 5 minutes, right? Then what happens is we've heard Treasury, we've heard you, then we respond. Then you respond to us and Treasury responds to you. So, we've got 3 hours and so please be fair to everybody else. So, I think the first person took up to 8.5 minutes, but he was entitled to 10, right? So can we stick to 2 minutes from now, please, man? Thank you.
Thank you, Chair. 2 minutes it is. Oversight of National Treasury, refer to Section 60 comments. Scope of procurement, remove contract management, asset management. The capacity of National Treasury, they don't have the requisite depth or breadth. They flip-flop too much in the past. And the procurement by other organs of state is largely unlawful in terms of the proposal. Going forward, our proposal is let's do this properly. It hasn't been done properly. The consultation process is fatally flawed. We have provided the 2 opinions. In our view, we respect there might be other views, and our recommendation is start again. We believe that in its current form, the procurement bill will do more harm than good. Thank you, Chair.
All right. Right. Who's next? But before we go on, can I make it clear to stakeholders, right, that while we fully recognize your right, and we want to hear you because many of your technical experts, we aren't, and we're unapologetic, we are politicians, okay? We don't have the expertise you have. in procurement, nor are we required to. We're required to have the expertise in our parliament to assist us in coming to a conclusion. Ultimately, these are political decisions, right? Like in every democracy. Now, I think if you go to the extreme of saying start from square one, I can't see this committee, the majority, agreeing to that. This bill has been in the pipeline for I don't know how long. National Treasury, can you answer that question first? When did you start on this bill, at least before 2014? So how long has it been with you? Secondly, how long was it with NEDLAC? And how many hours on average did you spend in NEDLAC? Maybe Kusato can help in that regard, or others can, right? But you see, at the end of the day, National Treasury is not obliged to accept all the amendments you propose, which conflict with each other because each of you has different interests, or some of you do, right? Then we are not obliged to listen to National Treasury. We are Parliament. We legislate. So we will hear National Treasury and they will say, yeah, we agree with you, here we don't. Same with civil society. This is a democracy. Ultimately, it's the elected politicians, whether they're good or bad, that's ultimately reflects on the election, right? We have to make a decision. That's our constitutional right, since people are throwing the constitutional issues so much at us, which is your right. So can we get this clear? Nobody is entitled to be heard on every issue or to be conceded to on every issue. But you have to be heard and you have to be given space to engage. And I've got some ideas, as mandated by our party, of what some of these options are. We'll come to that at the end. But what is very clear to me, National Treasury, you can't say noted, noted. I also noted your noted and said, now what is this? Where does this come from? Because when you say noted, what do you mean? What is your response? That's what we need. So let's start with this on your side, National Treasury. This is an inadequate presentation, really. And you can't be serious, really. And remember, this is a Section 76 bill. You have to carry 9 provinces or majority with you. So can we agree, on the one side, that civil society, you can't get everything you want. It's too late now. You could have formed a Public Procurement Bill amendments party to stand for election, right? So, you have a right to campaign for your political parties and wherever you want. But for now, you're not getting everything, and nor will you ever. That will be stupid. That means Parliament's supine, that we are toothless. We just populous. We just give in to all the civil society stakeholders. But on the other hand, Treasury, you know full well, you don't make the final decisions. Parliament does. Furthermore, I don't know why. Can you answer me these questions, Treasury? What happened? Why didn't all these issues get raised in the NA and be addressed? That too you must answer, Treasury. So can we agree there's no need to repeat, it's an inadequate presentation? It's utterly clear that it is. And Treasury, can we speak offline? Willie, MP and myself, about how we manage this process, really. This is not acceptable. I mean, it's not a good response. I got a letter from a rude one from an opposition member, typically him. But I must say, when I looked at it last night and this morning, I don't care which party says what. In my view is that it's not adequate. I don't know what the majority think. Maybe they're happy with it, in which case, fine. Right, let's go on now. There's no need to say, you know what, they didn't consult you at all. That's not true. NEDLAC, you were consulted. You didn't get what you want. So let's not go to extremes. Let's not polarize the discussion. Let's see where we can find each other by a give and take process, please. Okay, right. Let's go ahead then. Who's next? Corruption Watch, please. Can I make one final point, please? I'm sorry to interrupt because I think this thing is going a bit haywire. We will allow you, as very few committees do, if any other, to make further submissions, but you know what? Within 2 pages, in a pithy bullet point form. What is it you want and so on. And Treasury, don't come to us until you have a proper, comprehensive response, not every issue, okay? You can't have 5,000 amendments proposed, you can cluster them and then reply to them. But we will have to do this again, Treasury. This is not acceptable. But on the other hand, we can't have stakeholders also being intolerant to you and not recognizing their responsibilities. So 2 to 3 pages. You can submit this. What's today? Tuesday. Can we have it by Friday, noon? Send it to us. And next week, I think we're going to pay a bit more attention to this bill than I otherwise planned, or we planned, Kululeko and me, because of where we are. Right. And can we go on now? Because I'm going to be strict about veering away and repeating stuff. Just focus on the new things. Don't tell us who you are, please. We know who you are already, right? Right. Now, we know who Corruption Watch is. Don't tell us your role and all. You did it last week, I think. Right, Corruption Watch, are you here? Nope. Okay. Public Service Accountability Monitor.
I'm here, Chair.
Go ahead, please. You got 5 minutes. Thank you. Or thereabouts.
Thanks very much. We thank the Treasury for the presentation. We remain concerned that the bill does not create a clear and binding reporting, a set of reporting requirements that will improve transparency in procurement. So we note the responses that say that, there are sections on disclosure, there are sections on participation. Our submission, we highlighted a few issues there, but the main issue that we have is that there are already provisions in place in existing regulations that compel procuring entities to publish information, and they simply don't, or the information is incomplete, inaccurate, and insufficient oversight and monitoring. In our submission, we spoke about e-tenders and some of the issues there. There's not enough information. There are many errors. The procurement plans that are supposed to be for the next quarter refer back to, sometimes fictitious dates or out of date. But there are also challenges with the dashboards that were created, COVID-19 dashboard, disaster response dashboard. Again, there are errors, there's limited functionality, and they're not up to date. So, listening to the Treasury's response again, we're concerned that my understanding or interpretation of what they're saying is that they will revert to the system of circulars and instructions with optional compliance for local government. And we think that this, it just continues with the current scenario where local government just can choose to report and publish the information on procurement that they want, or not publish at all. And the second response from Treasury, that there will be no additional resources required to implement the bill, is also another concern, because the functionality of e-tenders and some of the e-procurement frameworks, they are inadequate. As I say, there are errors, there's information missing. So if there's no additional resources that's going to be put to it, then what changes? What's different from the current scenario? We know that it's not working. I think the comment made in the session this morning was that Treasury had succeeded in making the system completely impossible. So just a quick example, we are a CSO based in Makanda, a town that's now famous for water supply and quality issues. As we speak, large parts of the town are without water. They've been without water since the weekend. This has been going on for at least a decade. There's a boil water notice in effect due to high levels of E. coli found in the municipal water. But as civic actors, we cannot find simple, easy to access statistics on how much is being spent on water projects, what the plans are, etc. There was a recent session with stakeholders, Department of Water and Sanitation, the Water and Sanitation Committee, etc. And in that session, there was a dispute over how much is being spent. So we're concerned that not only can civil society not access this information, but also some of the critical oversight actors, the committees are unable to access the information. So really, I think, again, we appreciate the response. We do recognize that there are improvements, there are provisions in the new bill for transparency, but we're just not convinced that they are strong enough to ensure that information will be published in a format and easily accessible to the public to be able to conduct oversight or just understand what is going on in our municipalities, in the departments that we are tracking. And we think that this is a really, really important aspect of the bill, and possibly a bit less controversial than some of the other rather complex matters. We want information to be clear. We want entities to publish their information in a timely manner. And that's
You've got about a minute.
I have to say. Thanks. I'm done. Thanks.
We owe you 45 seconds, right? You're the only one that
Great.
based on time. So we'll give you more space if you had to come in again. Okay, next then is, who is it? It's Samet. Are they here?
Yes, Chair, we are here.
Go right ahead, please.
Thank you so much, Chair, for the opportunity once again. So I think we just need to reiterate our concerns, which I think need to be seriously addressed from a medical health perspective. And recognition that medical devices have very unique challenges within the procurement system, and a one-size-fits-all procurement plan is going to raise significant problems within patient care and delivery in the healthcare structures. Issues such as the removal of bid specification committees, strategic sourcing and value-based procurement from the bill is a major concern for our sector, as it has a direct impact on how healthcare practitioners are able to provide care for patients. We also raised the massive challenges that are between the current proposed procurement bill and that of what's contained in the NHI bill, and those irregularities, which are a major issue for us. There are significant contradictory requirements between what is proposed with the procurement bill, the NHI bill, and then what is required of specialist sectors such as healthcare within the Medicines Act and medical device regulations that are already in legislation. The proposed centralized procurement system that is proposed under NHI is again contradictory within the procurement bill. And from our perspective, we would rather advocate for a decentralized procurement system which allows for the care of differences in demographics and the disease burdens, and to allow that technical support and spare parts and training for healthcare professionals throughout the system is available within a local setting, rather than from a centralized national setup. The concerns regarding the removal of bid specification committees and such, it's the absence of a legislative framework relating to supply chain management and the way in which those committees work, that without those, will continue to see instances where inappropriate medical care is procured, and inappropriate implementation of contracts, healthcare professionals with medical devices not working as they should, and ultimately suboptimal health outcomes, as we saw during the procurement challenges we saw in the COVID-19 pandemic. Any kind of procurement system that considers price as a predominant factor is going to fail to account for the cost and value of the entire episode of care when you're dealing with patients, and will tend to favor older and more simple technology, which will unfortunately have a negative impact on patient needs and better healthcare outcomes in the long run. Concepts of value-based procurement, which has also been removed from the draft bill and no longer exists in the current bill, sets out important parameters to ensure that medical procurement is appropriate and responsive. Strategic sourcing has also been removed as a definition in the current version of the bill, and we really certainly would recommend that those be reinstated in consideration. Value-based procurement at the end is making purchasing decisions that consider how a product or solution can best deliver outcomes being measured and reduce the total cost of care at the end of the line, rather than focusing exclusively on purchasing a specific product at the lowest possible price. Anyone who's ever experienced patient care within the government sector, within the healthcare space, is fully aware of this is a system which can do so much better. But it is what is central to that is how goods are procured, how that system operates, and how it is planned. And without those correct parameters being put into place within those healthcare spaces, it will lead to a detrimental lack of delivery ultimately in the government sector, and patient care will ultimately be compromised. There is no other way around that. Thank you, Chair.
Thanks. You can also have more time when we come back, because you used even 1.5 minutes still to go. Willpower, and then Gabriel from IRR. Willpower, are you here?
Thank you, Chair. Yes, we are. I do have a presentation that I can share if you'd like me to, but let me kick off straight away. National Treasury did not acknowledge or respond to a recommendation which we thought was quite an important one, that Parliament and provincial legislatures should be fully included in the application of the Act. They didn't include it in the matrix and didn't respond to that. We think that's an important omission. There's an important definition change that Treasury have recommended or have agreed to around the definition of construction, and we welcome that. But the same logic should be applied to a definition which comes later in the bill around asset management. And Chair, we're extremely worried that National Treasury insists that asset management is part of procurement management, It just does not make sense that if we take Eskom just manages assets. Now the whole of Eskom is going to come under procurement. That's what Treasury are recommending. It does not make sense, and we think that should change. Throughout the responses, the Treasury are saying that complementary goals must be defined. And this relates to a point that Simon made around price. Chair, complementary goals is not understood by anybody except National Treasury. And it's a fundamental part of Chapter 4, the framework that 2173 requires. It's fundamental, but we don't know what it is. So unless and until that complementary goals is defined and we understand what it is, we do not have a framework. And I really encourage NCOP to engage with Treasury on what they mean by this, because it is just not clear, and without clarity, we do not have a framework. There is a very significant change that was made by Treasury to a statement where they corrected a mistake where it referred to a section which does not exist. And they said that instead that they should refer to clause 17.3. Now, this is a very significant and welcome change that they're saying we can now pre-qualify on the basis of Black women, and a whole range of designated groupings in 17.3. That's new. We've never had that before. And now suddenly with this correction, it is there. So that needs to be engaged and discussed a lot more. NCOP, and National Treasury said that one of the statements that we'd suggested, they will look at if operationally it doesn't work. And the statement related to subcontracting. And Chair, it's a statement where they say that when it comes to subcontracting, and subcontracting is a critical lever in transformation. And in provinces and municipalities, they want to be able to encourage subcontracting to their suppliers in their municipality, in their province. They will not be able to do that. The bill, in its current form, will make it, they're unable to do it, Chair, and this needs to be addressed now. They're going to have to choose between subcontracting to anyone in the country or subcontracting to any supplier in their area, even if it is a big white supplier. That does not make sense, and that needs to be looked at very carefully. Second last point, the reference to the panels within tribunals is welcome. National Treasury is suggesting that should be covered in the tribunal rules. We're saying this needs to be explicitly stated in the Act. They've acknowledged that there's a financial impact to this. So let's get it explicit in the Act and make sure that that comes through clearly. Chair, in the matrix, Treasury have identified another 30 recommendations, over 30 plus recommendations in the detailed matrix, and we fully support that those be addressed in the update to the bill. Thanks, Chair.
Thank you. You also will get more space if you need it. Right, let's go for it. Who's next? Gabriel from IRR. See here.
Greetings. Yes, thank you, Chairperson Kareem. I endeavour to be brief as well. Thanks. Greetings to everyone. I want to start by very specifically saying we welcome Treasury's recommended amendment. Clauses 62 and 63 currently say that the Minister and the Public Procurement Office may, respectively, grant exemptions in the Minister's case and deviations in the PPO's case from requirements of the Act in the first case and from regulations and in the second, if they are uneconomical, impossible, or impractical. And that
is it just me or I can't hear him?
No, it's all of us, Chair.
Okay. Gabriel, can you hear us? We've lost you there. Do Do you want to try to reconnect and come back? You'll have your full 5 minutes. In Kulileko, can you help there?
Chair, it's network on his side.
All right, you engage with him by phone, and then we'll continue, right? Are you back? Are you back? Gabriel?
I've
Switch off your video, Gabriel.
Switch off your video. Oh, he's left. Okay, can we move on then? Who wants to speak from the committee side? Is there nobody wants to speak? Wow. After all that.
There's
Dennis?
a hand from Mr. Ryder, Chair.
Okay.
You ready for me, Chair?
Yeah, you can have half an hour. There's nobody wants to speak.
Okay, perfect. Thank you very much, Chair. And yeah, I'm going to use it. So I think, first of all, Chair, before I start my inputs, maybe just to say warm congratulations to a friend of this committee who's recently been announced to going up to new heights. So hopefully Treasury will make sure that she works her full 30 days notice. So if the colleagues from Treasury can just pass our congratulations on to Dr. Mampo Madisa on her recent appointment. I think it's good news, and we wish her nothing but the best. Chair, right, let's move on to the, first of all, let me say again, thank you for postponing this meeting. I think we've had a much better engagement than we started having the other day. And I think that under the circumstances, it was starting to become a meeting that was going to end up being very angry and disjointed. I do know that Advocate van Schoor was very distracted by the problems that she was having. Not her problem, not her fault at all. But and I think that the engagements we've had today have been much more constructive. So I do welcome them, and I welcome your decision to postpone, to defer the meeting until today. So thank you very much. Just regarding some of the inputs today, I think that Professor Cloran, you spoke about the MAPS process, and it would be interesting for me. I mean, MAPS is a fairly new concept to me. It relates to, for those that don't know, an international assessment of South Africa's procurement system and procurement systems around the world based on international criteria. It would be interested to know, Professor Cloran, what your thoughts are on bringing where we stand on that, and is this bill, if it becomes an act, likely to stand up to that international scrutiny? I really thought that Kasatu's inputs today were excellent and spoke for most of us. It said that I think we all share a desire for an efficient system. That was the point that was made. But I do want to point out to Treasury that distrust should be expected. I mean, look at the Zondo Commission, look at all of the allegations, all of the comments. So you shouldn't be surprised by the level of distrust that this bill is being met with. And I think that the fact that there is going to be a court challenge, it is inevitable. And certainly, Chair, I think our processes should hold up to scrutiny when we get to that. And I think that therefore, I'd like to just ask Treasury. I had a look at at the inputs that they sent through, and I did note that KwaZulu-Natal, the Northern Cape, Limpopo, and the Northwest, those public participations were not detailed in the schedule, and Gauteng only had one event, one opportunity for public participation. If Treasury can just respond and tell us, is more planned? I do know that we've extended this, but are we on track to meet the public participation kind of thresholds that the courts expect from us? Ms. Higginson, drew the obvious one where Treasury says that no additional resources will be required, etc. And yet, I mean, the obvious thing is we're setting up tribunals, brand new tribunals. Who are we fooling if we don't think these are going to require massive staffing? But over and above that, I mean, there's lots of requirements, additional requirements from this bill And I think that Treasury's response on that leaves a little bit to be desired. Yeah, Mr. Scott pointed out the limited nature of the response and the various omissions. But he also pointed out the amount that's being left to the regulations, which are still going to be, coming through. And there's just too much that's up there and undecided. Complementary goals, set asides, the big jargon that comes through that I certainly don't have a grasp on as a member of Parliament. But the stuff that's being thrown out there, oh no, we'll deal with that later in the regulations. That's problematic because we're potentially going to pass a flawed bill based on expectations that something's going to happen down the track, but it's not going to. Yeah, I enjoyed Mr. Budlander's inputs. I think that Treasury's chosen to interpret it very much in their favor, and I think as is always the case with a legal opinion, where they're interpreting something, that legal opinion also needs to be interpreted. I do want to point Treasury to paragraph 42 of Advocate Budlander's response, and say that I don't think that they're covering themselves in glory here, and there is certainly going to be potential for further constitutional actions. Specifically, one considers Section 125 of the Constitution and 217, where it separates the spheres specifically. But we've unpacked that earlier on, and I'm not gonna beat that drum any further today. Right, and then the last thing that I have, Chair, please. One of the issues that we had right up front was the raft of amendments that were made on Chapter 4. Now, those amendments were made largely in comments in the report that was put through the National Assembly, and the actual defined clauses were not really agreed on by National Assembly. Now, the bill has come to us, and again, I see that there are amendments being proposed. And yeah, while some of them are certainly welcome, most of them are necessary. I do think we actually need to see the specific wording of those clauses. And I mean, there was something in Budlander's comments as well that said that, the first thing that you need to look at when interrogating a law is the actual wording. So whilst we as a committee and the public participation has resulted in certain principal changes being made, leaving it up to Treasury to crystallize that into the actual wording of the specific clauses that they're changing, I think is problematic. So before we adopt a report, before we get anywhere close to doing that, to have a look at what will it be, the C version of the bill or the D version, I don't know which it'll be by then, but to actually have a look at the specific wording, it's very important for my peace of mind. Thank you, Chair. 7 minutes.
No, 8 minutes 59 seconds. I don't know which phone you've got and stopwatch. Okay, fine. Can we ask Gabriel to come in now? I believe he's available to speak to us. Technologically speaking, he's available.
Yes,
yeah,
I'm back.
Yeah,
Thank you very much.
5 minutes here.
Okay, my apologies for this, and I'll keep my video off.
No, it's fine.
Okay. Thank you. So I'm not sure if any of what I was saying initially got through. I'll just repeat that.
Yeah, you can have 5 minutes. Yeah, start from the beginning, please.
Okay, thank you. So I want to say thank you to Treasury for their suggested amendment to Clause 62 and Clause 63 on the basis of what IRR Legal submitted. 62 says the Minister may grant an exemption from any requirement of this Act if effectively not doing so would be uneconomical, impractical, or impossible, create a procurement situation that's impossible to conclude. And our complaint there was that may confers discretion. So when it says the Minister may grant these exemptions, it also means that the Minister may not grant these exemptions. He or she may choose not to do so. And so Treasury has recommended, I think the committee should take it seriously, that it should be a must. The Minister must grant exemptions from this Act if failing to do so would make procurement impossible or impractical. And mutatis mutandis for Section 33 and the Public Procurement Office, which may, in the present version of the bill, grant deviations, and Treasury suggested that it must grant deviations if the alternative is an impossible or impractical situation. However, Treasury made it very clear that while it suggests this may should turn to a must, when it comes to that which is impossible or impractical. The may should be kept as a may when it comes to that which is uneconomical. And you can see that very clearly in the comment matrix. And I think the committee should apply its mind to the fact that Treasury is, in effect, very clearly saying, look, we agree, you must grant exemptions if the alternative is impossible. But when it comes to if the alternative is uneconomical, no, the minister may grant an exemption, and the minister may not grant an exemption. That's going to be up to the minister. So clearly, this bill, even in Treasury's mind, is there to grant executive authority to uneconomical procurement. The second point that I want to address in terms of just responding to what Treasury has said to us all today is it used the word transparency many times, both Advocate van Schoor and Mr. Matibula. And we welcome the fact that Treasury is now looking at Section 216(1)'s requirement for transparency and cost effectiveness. And we don't say that it wasn't there from the start. We agree. And I think it's good that Treasury's drawn attention to the fact that there are various occasions in the bill where it says, you know, this is for the sake of transparency. But there's a very particular point here of what needs to be made transparent. And those are the premiums being paid for the purpose of preferentialism or BEE, whichever way you want to describe these premiums. The question is, will the public know how much is being spent in general and on a contract by contract basis on these premiums? At present, the current system, and it's made worse by the bill, at present there's a situation where it is made to be as if it's corrupt inherently to pay such premiums. Of course, there's nothing corrupt about a black business getting paid a premium on the basis of BEE under laws that provide for that. The law is the law, and there's nothing corrupt about following the law. The question is, do the public get to know how much is being spent by the taxpayer, which includes the poorest of the poor, who pay disproportionately high VAT, how much is being spent on these premiums? Treasury has never said in a budget how much is being spent on these premiums. And the problem with this bill,
you have a minute left.
I hear you. Thank you, Chair. The problem with this bill is that it makes that even harder for the public to know, because the set-aside system and the pre-qualification criteria system means that no one in Treasury is going to know, no one in the procurement office is going to know what was the cheapest price available to buy whatever the good or service is, and by contrast, what is the extra being paid on the premium. So all of the talk about transparency is good and well, but our question is, where is the transparency about these premiums? How is the public going to know under this bill the amount of premiums being paid by taxpayers for the purpose of BEE or preferentialism, as the case may be? That question hasn't been answered. And until that question is properly answered, even for those who think that this is a good way forward, in general, the BEE premiums, this bill is going to be a failure. On top of that, of course, as is already known, we submit that the whole thing is flawed, but I'll leave it at that. Thank you.
Thank you. Right. Is anybody else who wants to come in? No. All right. For now, firstly, our own views for now, tentatively, depends also on what the majority think here in this committee. Firstly, this is a transformative bill. And invariably, because it's in such a sensitive area, it's going to be contested, and vigorously so, because there are rands and cents affected from a variety of different interest groups. Those who benefited feel that for all these years, including post-1994, that they're going to lose out. Those who feel excluded are demanding change. Those who are inside the system and have been advantaged by BBBEE and similar policies, affirmative action policies, are feeling a bit insecure because of the owner's requirements for public procurement now. And now it's become an election issue, which to some or other extent tempers people's views and makes us more polarized than we otherwise would be. So, some parties have made it very clear that they're standing partly on this thing of scrapping affirmative action and triple B, double E, and all of that. I can't see any party running this country and not having some or other policy and legislation of affirmative action in a country where, as we all know, our huge class and other inequalities are highly racialized, even if there are people who are formerly advantaged, who are now in low-income groups and unemployed and so on. So it's an election issue, and we should expect. But the degree of polarization is extreme. There seems to be no give and take from the stakeholders, well, very few of them. Secondly, I'm not going to repeat what I say, which is it's ultimately Parliament that decides. We can hear stakeholders, we can hear NEDLAC, we can hear National. Ultimately, we decide. Thirdly, of course, now, unlike other bills, most other bills we've had, and many of them are 75, there's a 76 bill. It's the wording that matters. As Parliament, we have to look at every little word. It's not enough for National Treasury to tell us in policy terms what they are agreeing to amend and us just agreeing with the policy. We have to look at the wording, because ultimately it's the lawyers on our side and us. Frank will take major responsibility, but we're not going to let pass National Treasury or anybody's stakeholders in civil society until we see the wording and to what extent it's consistent with the policy we agreed to. Then, on the matter of constitutionality, look, sometimes people who raise that issue are doing it because they genuinely believe something's unconstitutional. But often I've found, not always, and maybe half the time, not more, that people take a bill to court because they're unhappy with its policy. I have no doubt some other person or organization is going to take this to court. You know what? We are not constitutional experts. Our job is to ensure a bill is constitutionally sound based on advice of lawyers. There's no single lawyer I know of in our committee, and I'm most certainly not a lawyer. But I've learned a lot being in the system since 1994, especially dealing with local government and the spheres of government, and we had to ask on every clause in some of those bills, municipal systems and so on, is this legally sound? Can we do this, or must we make a may, must, and so on? So all I'm saying to you is, you know what? Those of you who want to take it to court, fine. We're not going to be threatened by that. It's not our ultimate decision. We're not judges. We are politicians. If the courts decide, ultimately the Constitutional Court decides the bill is sound or not sound, that's for them to decide. Our job is to ensure as far as possible it is. And Frank and others in the legal services unit will help us. If need be, we can have external opinion, but if that's necessary. Treasury, can you tell us, please, man? I asked this question, but please start with that. How long you have been working on this bill, and what is the extent of participation of civil society in NIDLAC and outside it, and so on. What else? Those are the general points. Now, on whistleblowing, another general point. I think personally, while recognizing the huge capacity and resource and money constraints, actually, it's disgusting what has happened to many whistleblowers. Every now and then, you read in the media, not only because of our failure as a state, including Parliament, but the private sector, for all its blabbering, they don't want to employ often, not always, people who have stood out and sacrificed, who have lost so much in income and threats to their lives. Some have died, as we know. It's shameful, really, what is going on in this country. We say we have no money, that's understandable. But there's nothing stopping this committee from saying in our report that we think what is going on is wrong. And yes, it's true, people will offer themselves as whistleblowers and they're not. They want to secure money. There are ways of trying to reduce the prospects of that. But it is terrible. Why should people come out and risk their lives and their income and their families in a society as corrupt as ours, if they're not going to be protected? Okay, let's see what the justice. But you're right, it's not the responsibility of this committee and this government department. Treasury, I mean, the other thing is people take on Treasury very unfairly. You know, Treasury is not government as a whole. It can't be blamed because the police and court systems are so inadequate, really. But what is true is that they're right. This bill that's coming up, the whistleblowers bill, I don't know when, it's an important bill. Nothing stops us in referring it to the Justice Committee. It's what we feel. On the matter of regulations and what should be in a bill, oh man, we started this process in 1998, dealing with the Municipal Structures Bill. The way I understand it, Frank, can you help us? If not today, the next time we meet. Actually, I'm not a lawyer, but advised by Parliament's lawyers and independent lawyers, when we sought external legal opinion, may and must don't mean the same things, Frank, am I right? In legal terms as they do in colloquial or ordinary English or ordinary speech. A may has almost a binding aspect to it, except if there are exceptional conditions in which the minister cannot provide an exemption. If you say must, then in every circumstance, the issue will revolve in the court around what exceptional circumstances are and whether it's justified or not. So I was given to understand, Frank, unless your predecessors here in your legal resources service and the external department lawyers and external were wrong. They say, you know, maybe something different depending on how it's worded. So maybe it's about a wording. Then on the issue of regulations and, you know, I come from the background, and I'm not the majority necessarily, that's very reluctant to provide ministers with the power to regulate unless it's absolutely necessary. And even in the local government sphere, when we shaped framework legislation, we kept saying, whenever the minister regulates, he comes to Parliament or she comes to Parliament or they come to Parliament and they tell us what the regulations are. And in some cases, we have to adopt the regulations within a month or sittings or whatever, so we don't keep them waiting and do nothing and then nothing happens. Or sometimes we have to table it and then we can comment on it. It's not binding on them. But we always consulted SALGA, as indeed the department did, and on these regulations. So I think we should look very carefully, committee as a whole, whether we want to give the minister too many powers. Then there's another theme that underpins our differences, maybe I've got it wrong, Tracy, but I think Esther and so on, I think it's the same old hoary debate, right? You're speaking to somebody who's a local government activist before 1990 and, you know, was really happy in the local government sphere, both in Parliament and as a deputy minister. That's the area I really like. It's what interests me. And I'm a very active proponent of civil society and its role. Let's not go there, but what I'm trying to tell you is take into account who's speaking here, right? And let's look at my background. I have shifted away from my romantic view of what's possible in local government, as indeed there have been thousands upon thousands of people residing in these municipalities. So my point is, you know what? I think it is important, as I've said in this committee on different occasions, to be less romantic. We do need more stringent national framework. We can't take over the powers and functions. It's unconstitutional of local government provinces, but we do need stronger framework legislation. And we do need, where possible, to disincentivize people from doing wrong and have, to the extent possible, in terms of the Constitution, penalize those who do at local and provincial level, which is not to say national government has a lot of capacity or resources, which is not to say that you know, local government is sometimes right to say, you say we don't have capacity. What about you at national level? We need to find the right balance there. We're not going to agree, but we can't have our cake and eat it. There are people here who will say, local government's doing this and doing that, and then we say, okay, let's manage them better from the national sphere without violating the Constitution. They will up in arms. You're usurping, being your stubbornness. That's not the word they would use. Neo-authoritarian, that's not the word they would use, but that's a subtext. Now, very quickly, I'm not sure I understand some of the things people are saying. So firstly, somebody said the legal opinion is very helpful. Can you kindly tell us how? It was on the civil society stakeholders earlier. Kosato says, take it back to NEDLAC, but you've been in NEDLAC for so long. Maybe there's another way out, which is what I think we must think about. Is instead of going to NEDLAC, which might be a ponderous bureaucratic process, we have done this on many bills in the committees that I've been in. We might consider asking National Treasury and the stakeholders to meet outside of a committee process, because we're on a constituency period for 2 weeks in April. And we're definitely going to make amendments to this bill. We have to send it back to the NA. I don't think there's an appetite to defer this bill to the 7th Parliament. If we have to, we have to. If the balance requires it, fine. But we have just sought an extension. All the provinces have been notified last week that it's highly likely that they will, National Treasury, your parliamentary liaison officer would have got the letters, not have to rush in any way. We're not rushing either. They've got more time. So National Treasury are under less pressure to be briefing the provinces all simultaneously. So, and we are not going to just rush blindly into this bill. So I'm informing you as stakeholders also that we are not rushing into this bill. We've got an extension. We've passed the 8-week cycle. So in terms of the cycle, 22nd of March, there's no constitutional challenge about it. Frank Jenkins can explain to the committee at some stage. We're within the 8-week cycle. I'm not sure how much more public participation we could do in an 8-week cycle, but we fought for not so much, partly public participation, but mainly content issues. They're too complex to rush. So that extension has been granted. I'm not clear. Somebody's talking about how small businesses will be penalized and so on. I wasn't very clear in what sense. I'll skip many of these things because I'm going to take too much of time. You see, there's a further thing here. National Treasury, why don't you concede that you have limited capacity and resources? And what you're seeking to do here is very ambitious, actually. We have been asking for years now that, before we started with the Child Justice Bill, we returned it to Justice Committee, Parliament, Justice Department, and said, no, we're not processing this bill. Firstly, we don't buy your financial implication stuff, but more importantly, show us you have the capacity to implement. Give us your program. So we delayed the bill for about 6-8 weeks until they gave us a capacity study, and I think they got somebody independent to do it. What are their resources and so on? Only after that we continued with the bill. So I think you have to accept that this is a very ambitious bill. You have to phase some of these things in. Have you got a program for it? If you have, bring it to us. Some of the arguments offered by the stakeholders now, local governments will be trampled on. I don't buy it, actually. I think it can be tweaked, the clauses in the bill. Ultimately, we must see how it's worded, and we can sort that out. At some stage, the ANC and the government was saying that, and some ministers, the best way out of this mess that we're in over public procurement and inevitable litigation and, how processes being held up and what have you, delivery and development being stymied, is to put as much information as possible in the public domain. If we are serious about tackling corruption, which is a major concern of all of us, why can't we put as much of the information as possible without actually being insensitive to market and other considerations? I'm not an expert in that area. None of us is, and so on. The complementary goals, nobody understands it, said somebody. Can you check on that, exactly what the person is saying and where the problems are? He did mention it. Can you please give us 2 pages on it? Can I plead again that at the end of this meeting, you decide of the 10 things you want, which 3 or 4 things you want to highlight mostly. Give us those 3 or 4 things, you can underline it and then see if you can raise the other 7 issues. But 2 to 3 pages is enough. The issue now is not endless discussion. We fundamentally will not agree. I don't think the majority party will. As a chair, you're not going back to the drawing board starting from square one. This is Parliament. Ultimately, you have to come back here. So, as far as possible, unless we come to a stage where we feel we cannot proceed with the bill, we will pass this bill this term. People will say, you see, Karim is under pressure from his party and so on. I don't think those who know me know I'm some sort of supine, servile, spineless chairperson, but you are free to do it. You know what? People have made this an election issue, right? And they have provoked responses to that. Yet they know full well, I think, let's not go there too far. Let me not say that. Can I say to you, look, we at this stage would like to pass this bill for a variety of reasons, most of which have got nothing to do with the election. But we can say, as we've done before, it's a transitional, temporary bill, and that within 18 months, because you've got a new term of parliament, people have to find their feet. Imagine this committee. How many of us will come back? Well, the last time, nobody from the NCOP came back, 2 of us from the NA did. And in the NA side, only 1 person was returned, Comrade Noxie, right? Dion George did come back. So think realistically of what's here. Let's see how much we can get processed in this bill. And those things that are too contentious, let's kick it out. But ultimately, remember, it goes back to the NA. And they can reject what we are saying. I think I'll leave it there. I plead with the stakeholders that they submit by Friday noon in a short bullet point type or table type set of submissions based now, not repeating what you said and being realistic about give and take, because apart from you that are here, others are not here who appeared before the public hearings last week or the week before, and there's so many others who didn't even appear. Then can Treasury explain to me what happened in the NA process really? Why the sudden change? And why it appears at the last moment? But ultimately, the NA, please understand, Frank, you can come in when you want to and say something. I don't think civil society stakeholders are being reasonable. There is a parliament here, whether you like it or not, and whether you like the majority party or not. There's an election coming up, you have choices. What I'm saying is, the NA has a right to make decisions in the end. So, I mean, really, I don't know what the complaint is. They're not obliged to go back to civil society and ask them, hey, do you agree, all thousands of you? No, they're not obliged to do that. Then I'm pleading with Treasury to just get a bit real, right? It is a very disappointing set of submissions, really. And we will talk offline, but this is not acceptable, really. We need a more comprehensive reply to what happened, to what people have said in the initial public hearings, what they are saying now in response that you haven't responded to. Everyone has to be responded to. If you need, beef up your staff. If it's too much on Willie and MP, you have to go, I'll speak to the DG if you want. So we can deal with those things offline. Having said that, because nobody else wants to speak, I took a long time, but I'm a bit now clear. We need to set a framework. People can't come here and repeat things they've said and expect everything that they are saying to us must be done, and Treasury will be done, and Treasury can't come here and tell us, hey, this is our reply. So both sides, please be understanding. Right, now somebody has put something on the, Sean has put something, what is this now? I'm not as fast as you might be, Sean. Sean says, Friday noon agreed, 2 to 3. Thank you, Chair. Right, Sean. Sean Scott, good. Okay, thank you. We're agreeing. Right, good. Now over then to Treasury first, and then let's see if we have time for the stakeholders to come in. Well, 12:03. I think we have enough time. I'm sorry to go on for so long, but remember, there are many other members here. If they all took their 5 minutes or 3 minutes, we would have used up more time than I have used. And I think that as a chair, I should have some liberty to set the parameters in which we're going to go forward here. I have already consulted with the ANC study group, and they will also speak as necessary. Right, good. Can we go over now to Treasury? And please reply concretely and precisely. Also, if you don't have the answer, say you'll give it in writing. Thank you. And tell us what you think of the suggestion that you and the stakeholders, yeah, let me put this more clearly. Can anybody who disagrees with me raise it, from whichever party? This is a chair trying to direct as a representative of the institution now, not of the party. I'm saying we can't sit here endlessly and look at very finite technical issues and to and froing, right? And the stakeholders from civil society can attend. There's no obligation for us to include them further, but they are always welcome to send submissions. So, Frank, I think you take over the constitutional issues, and I would like to suggest to this committee as a way forward. Apart from your responses now, Treasury, we don't deal with the constitutional issues here. We get a report from Advocate Jenkins within 2 weeks. Well, we've got a constituency period, so we can work out the time. He's very, very busy at this time of the year. We can work out a time. But before we meet again, 48 hours before we meet, we want a reply about what does Parliament think of the constitutionality of a bill, of this bill, right? So that's settled. That is the decision we take. Committee members, if you disagree with that, you can say so just now. The second process issue, to make things easier, to calm down everybody, is instead of a NEDLAC process, why don't we ask you people, as we've done with government departments before, not least Treasury on the VAT thing and sugar beverages thing, but sugar beverages went to NEDLAC. What we are saying, can you meet? You've got 3 weeks before we come back. I think 15th, is it in Kulilek, or is it 16th of April we come back? Am I right? 16th, 17th of April, right?
That's correct, Chair, 16th.
Yeah, by the Friday before that, you can engage with our dates. We want a report on what issues now you're agreeing on, what issues you're disagreeing on. Both sides recognizing that ultimately it's our call, okay? Now, Treasury, you can't be doing all these thousands, metaphorically speaking, of people. I'll suggest what you do is you can cluster them, and like SAMED is completely separate in some ways, right? Public accountability is slightly different, and meet with them, or meet with them individually, or meet with all of them together and give us a report. If the committee agrees on this, I will engage with the DG further if necessary, but before which I would like to speak to the two of you about process issues. So we'd like to know whether in principle, we don't need your permission, but we would like you to have a buy-in. We know you're extremely busy, but you know what? You've done so much work on this bill. Let's see where we take it. Thank you. Right, over then to Treasury.
Yeah. Thank you, Chair. Let me start. I'm sure the advocate will also add. The issue that I want to start at, Chair, is the question that you've raised around the process. When did we start with the process? And leading to where we are today. Look, I'm not going to talk to the process preceding the public participation when the bill was published. So the bill was published.
No, Ms. Willie, the question to you is, when did you start with the bill?
Oh, okay.
You must answer. You can't decide you're not answering, Willie. I mean, you can't. Yeah, it's Parliament. So the question to you is precisely, which year, it started before 2014. So which year did you start working on this bill?
Chair, thank you very much. Let me speak to that. In 2014, in fact, let me start there. 2014, I think Cabinet then took a decision to say the procurement process in the country must be modernized. So that's the time when the entire process then began to put the building blocks together. Then we started the process of drafting the bill at that time. And the bill was drafted, of course, consulted internally within government institutions. And eventually, we then took the bill to Cabinet. And to be precise, I think it was on the 5th of February 2020 when we went to Cabinet. And then Cabinet granted approval for the bill to be published for comments. But as we indicate, this is about 10 years ago. So then 2020, February, the bill is published for comments. And if I may just indicate, Chair, almost more than 4,000 comments were received. All right. And then, Yeah, so the Treasury team had to work through that process of looking at all the comments, the 4,000, comments that were received. And out of that process of, assessing the comments and so on, then that process culminated into a bill. And of course, that bill then, the Minister of Finance at the time, Minister Kotongwane, the current Minister of Finance, then requested that this bill should be subjected to the NEDLAC process, so that the social partners at NEDLAC could also have an input. So then this bill was then, sent to NEDLAC in April, so that the process of NEDLAC started in April 2022.
Oh God, 2 years. Wow.
Yes. So April 2022, and then we had a number of engagements at the time, with the social partners, different meetings, of course. And in that process, there were a number of other issues that we discussed. Some of them we said, no, these we agree, but we must also agree to disagree on certain issues. Yeah, at NEDLAC. And we then highlighted some of the issues that we agreed on, and NEDLAC produced a report to that effect. So the NEDLAC process started in April until the 7th of October 2022, I think that 6 months period. And a report was produced. And all social partners signed off on that report. And that report, I still recall that we signed it on the 25th of October 2022. And then the report was then submitted, of course, through the procedural processes to both the Minister of Finance as well as the Minister of Labor at the time. So that's what we did. And after that process of the report having been produced and all of us signing, those that were leading the social partners, I was the government lead at the time. And of course, we had other social partners leading and so on. And then the bill then within Treasury as well had to be discussed with the acting DG at the time. And eventually we requested permission from him to take the bill to the state law advisors, the Office of the Chief State Law Advisors, which we did, of course. And as part of the bill in that process as well, we did CIAS. And the CIAS report, of course, was produced by the presidency through the DPME. And then we had that report.
Explain to people what CIAS is, they may not know.
Oh, CIAS is a socio-economic impact assessment. So that's what CIAS is all about, socio-economic impact assessment report. And then that report is produced, and then the presidency issued a certificate to say, no, we've looked at your CIAS report, the issues that are there as the presidency, and then we then give you a certificate to say, now you can proceed with this bill to the next phases. So when we submitted the bill to the Office of the Chief State Law Advisors, was some around 2022 in December. So we submitted that report, but of course, the NEDLAC report had always been there. The state law advisors, of course, looked at this bill, and then they also gave us their report around February 2023, because we're now rushing to make sure that it's before the end of the financial year.
We know the process after there. Yeah, we know the process after there, right? It's just that I don't want to consume. You've been given us a very comprehensive report, right? Now, if they reply, you know what they're going to say. You're going through the motions, the usual stuff, right? As far as I'm concerned, it's been germinating for 10 years. You had 6 months in NEDLAC, okay?
Yes.
And maybe after that, did you engage in NEDLAC after October 2022? Did you engage again in NEDLAC?
No, we did not engage in NEDLAC after that time, because now we did.
Yeah. Okay. Then when you published the bill, you got comments from all the colleagues here. Is that correct? Or most of them? when you published it, right? For gazetting, when you gazetted it, right? So they had all that.
Yeah, that's
right. Now they will say, what's in the bill that got to National Assembly and subsequently got to the NCOP is very different from what they negotiated in NEDLAC. So the subtext will be, I'm just summarizing what they're going to say, right? And they mustn't come back on this unless I'm saying something that they haven't said, right? Or think that what you did was you went through the motions. Yeah, you gave in on some things, but on fundamental things you didn't. And still what we got in the NCOP now is a far cry from the NEDLAC process. But strictly, that's fine. Your government, you introduce a bill. We Parliament, we decide on the ultimate outcome. So I don't see what's wrong in the process, but the quality of the engagement, they will say something else, you will say something else. And you know what? It doesn't matter. We are where we are. Fine. Okay, can you move on to the next issue?
So that was just the...
that's just reply. Yeah. Can I suggest a way out here, colleagues? Do a quick reply, right? And then what we do is get you, because, we don't want to wait for another 3 weeks now. We would like you to, if it's possible, we can negotiate offline early next week, at the latest, maybe next Tuesday, to give us a fuller, more comprehensive matrix, which responds to all the issues raised here that haven't been responded to there and which have been left out, right? So you've got a week. Now, if colleagues from civil society and so on, we will send it to you. If it's not here by Tuesday, please know that the chairperson has some discretion, taking into account that these people work very, very hard, right? Most of them, right? And Treasury, whatever else you say about them, whatever our disagreements, overall, these people work very hard. And they're under siege here. So you must leave it to me that at an appropriate time, preferably before next Friday, can we please have a fuller reply, right? So in the meanwhile, you and MP, can you reply to everybody else? And I'd like 15 minutes at the end. So why don't you take about 20 minutes or so, and then 25 minutes, and then the last 15 minutes or so, we hear from others. Thank you. Go ahead. To all the issues raised, yeah. I think you've muted, Willie. Are you muted?
Yes.
Oh, we can hear you now. Yeah. Good. Thank you.
Thank you, Chair. Let me start maybe at the end and then all the way to the beginning. Look, the first thing that I wanted to speak to is this issue around the premium. I think I'm happy that at least the stakeholders do acknowledge the fact that in this process of transformation, or in this process of the bill, there is no way that you are not going to pay premium. So the state has to pay premium, as is in terms of the current legislative provision. Now, as to what percentage going forward is the state going to pay, it's something that we said in Chapter 4. If you look at Chapter 4, that we will publish proposals for comments, because in the earlier iteration of what was submitted to SCOF, there were, conflicting views from stakeholders. Some stakeholders saying, no, the price has been discredited around the world as an instrument to evaluate tenders. So then we said, having looked at the comments, many comments, by the way, that came from the stakeholders, in particular related to Chapter 4, where stakeholders are saying, but the Chapter 4 in its current form at that time, as published for gazetted for comments in 30 June 2023, that Chapter 4, did not have the necessary details on exactly the issues, the principles that were contained in there. So they wanted us to go back and elaborate a bit. So this is where this elaboration or expatiation in Chapter 4 came in. But it does not mean that the principles that we expatiated on in Chapter 4 in the current version, that is before, the committee, were not there in the earlier version of the bill as gazetted for comment. These principles were there. I can just make an example. The set aside all the issues around industrialization. These issues come from the NEDLAC processes and the bill that was agreed upon at NEDLAC. So all these issues came there. So all that we did as National Treasurer was to say, let us at least expand on those principles to give at least the committee at least an indication of what exactly are we talking about. Now coming to the criteria for evaluation, because that's where you pick up the percentages in terms of the premiums that government has agreed to pay, and also to use procurement as a strategic lever to drive socio-economic objectives and, of course, other policy objectives of government. Then we said we are not going to do this discreetly, but what we will do, we will come up with the evaluation criteria, which will include the price, but we need to publish that so that the public at least has an opportunity to comment on that particular issue. So I think this is where we are, Chair, insofar as the premiums are concerned. I know in the current system, as provided for in law, there are premiums that I did speak to, in terms of the maximum premiums that the state has agreed to pay in terms of the preference point system that we have. So the public will have an opportunity to comment on what we will publish at some point in time, and we'll take the views of the public when we come up with whatever is going to be prescribed by the minister through regulations on the, Now added to that, Chair, we have in different sections of the bill, different clauses where we talk about transparency, that the public will have access, for instance, to certain information that's contained in clauses 32, 33, and so forth. So where the public will definitely have a disclosure of information for transparency reasons. I just want to assure the stakeholders here that there is no way in which the bill is structured for us to hide certain information. Public will have full access to information. That's one part that I wanted to address, Chair. The second part that I must address is an issue that is raised around the removal of the bid committees. It's incorrect, Chair. If you look at clause, I'm just going to go to the clause in the bill, clause 29 of the bill. It's quite explicit there. That clause refers to bid committee system. And as to how the committees are going to work, it's also provided that the minister must prescribe the system of how this is going to work. So it is there. Now, one other issue around the removal of strategic sourcing. I must indicate, Chair, it's a technical issue. Strategic sourcing is just one form of sourcing strategy. You've got a number of them. Strategic sourcing being one. So, but what we did in this chapter 5, we said there in chapter 5, everything that government procures, whether you're talking pencils, pens, and so on, you need to apply a strategic approach. We even made an example that, when the stakeholder said, no, but when you buy infrastructure, capital assets, and so on, you can't use the same method as you buy pens and pencils. And we're saying here, look, if you take education as a sector, that whole sector is a big sector, Chair, you know. And in that sector, there are pens and pencils for pupils, schools, and there are textbooks and so on. So government can't just go blindly and simply say, because you're buying pens and pencils for schools and so on, therefore you can just follow any other route. So we are saying there must be a strategic approach. And that strategic approach, of course, that we're talking about here would include the strategic sourcing as one of a method. It is a method. There are many methods that you can use in procurement. In fact, that is why in chapter 5, we don't want to detail all procurement methods in the primary legislation, because procurement evolves. It changes from time to time, and therefore Hence, we're saying the details on procurement methods and so on will be contained in the regulations because it becomes easier to accommodate new innovation. That's why in the bill we've got innovation, because that innovation is also another form, a method of procurement that we need to follow. So I think I must just also talk to this issue, Chair. And then the issue around the complementary goals. I think we've acknowledged in our responses to this committee that this is something that we need to define, and we've agreed to that. We'll define that part so that there is clarity in terms of what exactly do we mean by the complementary goals as contained in Chapter 4 of that bill. The issues around subcontracting. The first thing is we are saying where feasible to do so. That's very important to note. And the second part, we are even providing for geographical areas. So it's not only left at national or provincial level, but even to a geographical area, which would be a locality. So the contractors would have an opportunity to subcontract within a geographical area. And this is what we're saying, the institutions, the procuring institutions of government must implement a system within a system, and in their policy, procurement policy, must provide for a lot of these things. But definitely the guidance will be provided on all these issues, in the regulations, Chair. Then the one other issue that I must address are issues that refer to the current system, the accessibility of information from, for instance, in the e-tender portal and the central supply database and so on. I mean, in as much as we agree that any system would need to be enhanced from time to time, but we think this is the best system that we have in the current form. We can, of course, scale it up, enhance, with development and so on. But at least the public now is able to access that particular platform and see what are the procurement plans from various state institutions. And it even includes, because those are published on an annual basis, what each department is going to procure, what each state institution is going to procure. That information is readily available. So the public can access that information as we speak, but without discounting that, there could be some issues like in any other system, Chair. Now, the one other thing that I must also speak to is around the issuance of instructions and circulars, which we're referring to here. Look, what we're saying in the bill, yes, it is true, the PPO will issue instructions, but instructions are for augmenting where there are gaps. That's the first thing. And the second thing is, we said here, unlike the current system where we issue the instructions, many of them that are in the system as we speak right now, where people are complaining that Treasury keeps on issuing instructions and the officials can't keep up with those issues. And some of them, by the way, unintentionally lead to the irregular expenditure that we have in the country. Now, the instructions that we are going to issue will also be published. We've made that provision in the bill. Will be published for comments by the members of the public. So it's not going to be something that is issued by Treasury and the public does not know, because at least we're talking about transparency. And I must also indicate, Chair, that the entire bill is premised on all the sections that we referred to, 195, 216, and 217. And of course, we know what the principles of 2171 provide, one of them being transparent. So it's completely going to be a transparent system. And I understand that there could be some element of mistrust in the system based on what is currently out there in terms of corruption and so on, which we all as a country complain about. And I always say to my colleagues, you see, I have yet to come to a country that is able to regulate or legislate greed. Because corruption is, of course, a function of greed, Chair, if I may just put that way. So we can have the best piece of legislation, but we can't guarantee that whatever we have here will definitely deal with all the issues that relate to corruption. But at least what we've provided for in this bill in Chapter 3, and not only in Chapter 3, but in many other areas of the bill, we believe those are fundamental principles that should, form part of what one would call the guardrails around what we would do to people when they misbehave. So that's that part. The consultation process, we've spoken to that just now, Chair. I'm not going to go back there. Now let me come to this issue around of automatic exclusion. And I'm glad, Chair, that you are at least commanding us to go and meet, right, to talk about these issues and submit a report. Now, this is a position that we've taken when we looked at the original provision of automatic exclusion. So these are people that are going to be excluded. And part of them, of course, were leaders of political parties. Now we said, look, we understand if the leaders of political parties are also part of parliament, they are in parliament. But if there's somebody who leads a political party, not necessarily in parliament, we still believe that those leaders who are not necessarily represented in parliament, they are just like ordinary people and so on. They may not necessarily have an influence and so on. So this is where we then decided that perhaps leaders of political parties, to avoid an element of somehow encroaching on their constitutional rights, they should also have an opportunity to do business with the state as long as they are not in parliament. That's one. The second part, Chair, that we said under automatic excluded people, we looked at the extent to which the original bill covered a number of people that should not participate in a bill. We said there is an issue around cultural diversity being one, which we think our law should also consider, in the sense that currently you have blended families. So 1, 2, the original bill said Willie Mathebula's niece and the child of the niece and the grandchild of the niece cannot participate. And we said you can't have it that way. It can't be open-ended, because then what you are literally saying, you are saying, if Willie Mathebula is working for the treasury and for government, and therefore Mathebula's family can't do business with the state, and we don't think that is correct. That's one. All right. But even there, we put a limit to say, let us look at immediate family to Mathebula. But if it goes further, than where I am sitting, it becomes problematic. So we can't, therefore, that's how we dealt with this issue. The third issue that we discussed at the time was around the small dorpies and villages. Now, here's Willie Mathebula working in a small dorpy for government. And the government in that small dorpy is the only employer. So in other words, is the only, economic instrument through which the people around that small dorpy must earn a living. Now, the fact that there is Willie Mathebula working in that small dorpy in a municipality or something should not then, therefore, deny his family to do business as long as Matebula, of course, disclose a potential conflict of interest. In fact, what we said in clause 11, we said, let's look at all these things and make sure that where there is a potential for a conflict of interest, then therefore that has to be disclosed. And if Matebula happens to participate in a bid committee or any one of these bid committees, then Matebula must declare, because it must be on record, and he must recuse himself from that process. Because otherwise, you're saying that family must, where should it go to go and living? Should it be that because I'm working? So this, but I think these are issues that, Chair, we will discuss as you directed that we'll go and discuss these issues and of course come up and agree on what we need to do. Now, there's this other issue around the NHI and what the NHI proposes and what this bill is proposing. And we looked at the clause 3.4 of the bill talking about the trumping provision. We can always look at that issue. To say, what we're saying here in terms of this bill, there isn't necessarily central procurement or centralization of procurement. But what we said in our response is that, look, the relevant government procuring institutions would decide whether they want to centralize or they want to decentralize a procurement system. It could be for the economic benefits out of economies of scale and so on and so forth. But they will decide. But as the principles in this bill, we have yet to come to a provision that says you must centralize unless you're doing transversal contracts and so on, which is also another method of procurement. So, but beyond just that, we have said in chapter 5, there will be a differentiation in this process. So in other words, it's not going to be one size fits all. So we're going to have like regulations that talk to all the sectors in their different forms and shapes, including also the different procuring institutions of state, because ESCOM does something else, Transnet is in a different kind of sector, etc., etc. We will have regulations to talk about all of them rather than clapping all of them into one kind of procurement system. So I'd imagine that when we deal with that part, the issues that relate to healthcare and medical technology as provided by some of the stakeholder summit in particular would also fall within that particular area, Chair. I think, Chair, thank you very much. I must stop here. Thank you very much.
Oh, no. What I was going to suggest is, look, we're more or less agreeing that you will meet with them as an, to the extent, well, as often as you need to, but ultimately recognizing that you are the executive and you bring a bill to Parliament after consultation. So it's important that you reply as fully as possible to the committee right now. And what I was going to suggest, if you want to, you see, the only issues that are remaining is because they're going to meet with you anyway. It's for us to understand the issues better. So we just need 5 minutes on process. So you can take up to another 10 minutes if you want. And if they're unhappy that you haven't replied to anything, they will send to Inkululeko, a thing to say this question wasn't answered or whatever. Okay. So do you want more time or you think you're done?
I'm done, Chair, for now. Thank you, Chair. I think I'm done for now.
If you're done, you're done.
And then, yeah,
sorry,
but there's one issue. There's one issue, Chair, that if the Chair can just allow me.
Yeah, sure.
The MAPS process. It's a process that the Treasury is engaged in to modernize public procurement. But of course, we are benchmarking against the international best practices, and the OECD is part of them, and the World Bank is part of it. And then with regard to the questions on the public participation in Limpopo. Yes, Chair, last Friday, there was that session in Polokwane, but the previous Friday on the 8th, there was also a briefing of the legislature there. Now, Northwest did not take us, to come and participate in their sessions. But on the last day, they said, no, we want you to participate. But that time we were all over the country, in Eastern Cape and so on, and doing those. So we could not go to there. KZN did theirs, Chair. So they don't invite us. I think it's important. And Gauteng were there physically. And we don't know in the legislature. We're also waiting for the legislature to come back and say if they want to have public participation, but we are all in their hands, Chair. Thank you, because it's a parliamentary process.
Okay.
Let me stop here.
All right. Okay, Willie. Now, in the chat, there are some issues there. Let's see. Yeah, somebody asks, what happened to negotiating mandates? But the province is now, Frank, I think we should write a letter to the provinces. I've sent them letters saying, they're talking about the extension and all that, about the process henceforth and dates, okay? But do you want to say anything on that now, or would you rather just draft a letter and send it to me and I will see what's it like and we'll forward it? Is Frank here? Oh, has he left us?
I haven't, Chair. I haven't. There's just
sorry, yeah, the usual difficulties.
Yeah,
yes.
all kinds of things. You first have to press OK.
Yeah.
Is recording.
Yeah. Okay, sorry.
No, Chair. I think the issue that the negotiating mandates must come to the committee. We've given extension. The committee has given extension. It's followed the rules in the NCOP. You're well aware of that. The committee received permission, as you indicated earlier, from the chair. So I think it would actually be helpful to indicate to the provincial legislatures when those negotiating mandates must come through at this stage. I think everybody heard you when you said it cannot continue forever the to and froing about certain provisions in the bill. And the negotiating mandate process is also, it has a certain form that we must comply with. There's an act that also determines it. So I think, Chair, that is fine, and we can draft that letter. And Chair, there were a few questions on the must and the may, but I would like to just look at those in my free time and then get back to the committee. The public participation issues, I think, runs into the constitutionality as well, the must and the may, and then the whole Chapter 4 issue, whether it is a Section 217 1 and 2 issue, or whether it goes further and goes back into that the court judgment that National Treasury also referred to, Chair. Thank you, but that's at this point there's nothing else to say.
Yeah. Can I just clarify this? If I understand correctly, I engaged with you at the outset. You don't know, and it probably didn't happen, but we don't know, that the NCOP has sought an extension of an 8-week cycle as prescribed in the Constitution. This is the first time it's happened.
Chair, I was not aware of it before. Usually we just continued with it, so I'm not aware, especially in the new rules. The NCOP rules were changed to 2021, and I don't think it's happened since the new rules came into operation, which changed it from at least 8 weeks. Before it was not more than 6 weeks. So I'm not aware where formal request for an extension of that time frame has been requested, as we did in the case of this bill, Chair.
All right, so the issue about the negotiating mandates and so on, excuse me, is something we can discuss offline, bearing in mind that this is a new process, a new set of rules within which we've got this extension. Okay. Then the next one is about, what is it? At the very beginning of the public. Yeah, nobody's obliged to do that, Mr. Grace. You want to be involved from the very outset. It's not something Parliament can legislate to a department. Some do and some don't, but it's not a constitutional legal obligation as far as I know. The removal of previous Chapter 5, I read this. Treasury, can you give a quick reply to what Monica is saying? The removal of the previous Chapter 6.
Chair, let me talk to it. Look, the chapter 6 in the previous one, I think it was mainly on infrastructure. That was the 2020 consultation processes before even this bill was gazetted. So it was more the public comments that were made at the time. So it was in that bill that was published in 2020 for public comments.
You can just start to reply with your matrix, right? Just remember this question. Right. But it's Gabriel to everyone. Okay, let's go back to Monica. Monica, can you just email this to Nkululeko, our secretary? He'll forward it to National Treasury. Gabriel asked on transparency about the... Yeah, okay. Can you reply to this in your... Can you, Gabriel, send it to Nkululeko as well?
Yes, gladly.
Yeah, and then somebody's asked for midday Monday. Yeah, okay, fine. But you know, it's cutting things fine for us. All right, Monday is fine. Those of you who can send it before Monday, that would be great. I mean, tomorrow's a working day. This afternoon is a working day. Friday, as far as I know, is a working day. So I can't see why it can't be done. Well, if it absolutely can't be done, you can bring it in on Monday, but I think Friday is the deadline. There's no use coming and blustering here, and then you're given an extension, which Parliament's not obliged to give you, but we'd like to give it to you. I think Friday is reasonable. Otherwise, Monday latest. In the meanwhile, Treasury, we will discuss offline, the deadlines and so on. Right. On the matter of process, are we agreeing that they must go back, before they come back to this committee, they must meet? And it's not a nominal thing, Matebule. Really? It's not a nominal thing, okay? You must be serious about it, right? And ideally, I don't know how you do it, but I have suggested before that one or two people coordinate from civil society side the writing up of the report. And where they disagree, that it's not what is agreed to, they can put in, we disagree on this thing and so on. Ultimately, we're trying for you to bridge the gap, not to come to 100% agreement, because you're not going to do that, right? And then for us to decide, we can reject everything that you've agreed on. It's our call, right? And then you go to the court for that. There's no court that's going to, agree to that. There might be other constitutional issues, but are we agreed? Anybody objecting? No hands are up. So that's the process. The deadline for a report, you can discuss the process and structure, is the Friday before the Monday Parliament opens. I think it's 17th or so of April, okay? So don't give us two reports. Or if you want to give us two reports, it's fine. Do one report and say, we couldn't agree on this. We don't agree on this. We agree on this. You can do a table. But also, if they're unhappy with the content of the table, they can submit something separately. I don't want to go into those things. If you want to discuss it offline, we can do that. Now, there's another message. I'm not taking any more messages. We're wrapping up. Happy to engage with. Okay, right, fine. Right, so where are we? We're at 47. Oh, we got more time, but we're not going to use this time unless members want to say something now about the process. Excuse me. What else do we need to know? Anything members want to raise about the process henceforth? No. Right. Then, finally, is there anybody in civil society now who feels that they have a burning need to raise something that has not been responded to, that they raised in the first period of this meeting? Is there something you asked that's not been responded to? Anybody? Or would you rather leave it to the process? Yeah, I think maybe leave it to the process because you're unfair. Somebody else might want to speak and so on. So can we draw it to a close? Is anybody want to say anything about anything to do with this bill now? From the committee side, I mean? Nope. Right. Now, can I suggest to the committee members, excuse me, we are going to meet tomorrow, today, after 4 o'clock. And let's see where it goes. If possible, we should meet again at 2 o'clock tomorrow, because there's no sitting of the plenary, if there's consensus on going forward in that way, and consider a report on the Revenue Laws Amendment Bill. Dennis has sent something through. I've referred it to Frank, and the committee's got it now. That will be considered. Asisa has given us a submission. fine. So you've got it. And there's a last submission that's come well beyond the date. I mean, the closure was last week, I think. But we said, okay, we'll accommodate them. So that's then. Now, next week, we should finalize, if we don't on Wednesday afternoon, the Revenue Laws Amendment Bill, but then it means we won't take it to the House next week unless we suspend the 3-day rule. Then secondly, we can get a briefing on the Pension Funds Amendment Bill. And I think we're dropping public procurement now because we're not ready to proceed. So in Kuleko, do you know when the National Assembly is finishing the pension bill?
Chair?
Yeah. When are they
Yes,
finishing the pension bill? The committee?
The information I got from Alan, the committee is adopting its report sometime this week. So it should be in the House by next week.
No, as long as they've adopted it, then what we do is we meet on Tuesday with the bill. But you have to check when check with Frank Jenkins, the advocate. Can we advertise for public hearings if the committee's voted on the bill but the House hasn't? I think we can. Then we can go ahead with the public hearings. But otherwise, we can defer the public hearings to when we come back. Okay, is there anything else in Kulileko we need to form the committee?
Other than this afternoon's meetings, Chair, there's nothing.
All right. Our constitutional questions with Parliament, ultimately, yes, it's not a Parliament so much as the legal advisors of Parliament. And unless we can see something wrong in what the parliamentary law advisors say, I mean, the Parliament Legal Services say, then we accept it. But if you want to make submissions on that matter, you're welcome to send them to Nkululeko and we'll forward it to Treasury, Mr. Professor or Mr. Clarence. Thank you all. We shall see you later today after the House rises.
Chair, who should we submit our applications for overtime paid to? Kululeko, I think he ran away. You better ask him that offline. Thank you all.
I'll do so, Mr. Ryder.